defendants jointly and severally to allow the claimant to perform his lawful duty as the chief legal officer of the first defendant. A mandatory order of this honorable court compelling the defendants jointly and severally to pay the sum of 10 million naira, 10,501,560 naira only, being the claimant's salary at the rate of 291,710 naira monthly from 22nd day of May 2017 to the 21st day of May 2020. A mandatory order of this honorable court compelling the defendants jointly and severally to pay the claimant's salary at the rate being paid to the director in the first defendant employment from the 22nd day of May 2020 till judgment is finally delivered by this honorable court. An order of injunction restraining the defendants, their agents, previous associate, or any person claiming or deriving authority from them from denying the claimant access to the first defendant to perform his lawful duties as the chief legal officer of the first defendant. An order awarding the sum of 500 million naira only to the claimant, being general, exemplary, and punitive damages against the defendants jointly and severally for the hardships done to the claimant by denying the claimant access to perform his legal duties as a chief legal officer of the first defendant, his entitlement, benefits, promotion, and other incidental loss. An interest of 27% per annum on the total judgment sum as may be awarded by this court from the date of judgment until same is finally liquidated. The claimant predicated his claim on the statement of fact and witness statement on oath filed on the 22nd day of August 2022 and reply and further witness statement on oath filed on the 3rd day of May 2023. The first to fifth defendants based their defense on a statement of defense and witness deposition of oath filed on the 8th day of March 2023. The sixth defendant predicated his defense on the statement of defense and witness deposition of oath filed on the 4th day of May 2023. At the plenary hearing held on the 16th day of October 2023, where the claimant called his witness, the claimant who testified for himself, hereinafter referred to as CW1, identified his deposition made on oath on the 2nd day of August 2022 and 3rd day of May 2023 and adopted same as his evidence in support of his case. CW1 thereafter tendered exhibit CW001 to CW010. On the 30th day of November 2023, the first to fifth defendants opened their defense. Professor Teddy Charles Adayas, herein referred to as DW1, testified for the first to fifth defendants. DW1 identified his statement on oath filed on 8th day of March 2023 and adopted same as his evidence in support of the defense of the first to fifth defendants. Also, Mrs. Tariri, the BP, herein referred to as DW2, testified for the first to fifth defendants. DW2 identified her statement on oath filed on 8th day of March 2023 and adopted same as her evidence in support of the defense of the first to fifth defendants. Lastly, the sixth defendant called his witness. The sixth defendant who testified for himself, herein referred to as DW3, identified his deposition made on the 4th day of May 2023 and adopted same as his evidence in support of his case. After the close of hearing of this suit on the 21st day of October 2024, the matter came up for adoption of final written addresses filed by counsel. Learned counsel for the first to fifth defendants, Dr. P.J. Fowle, identified his final written address filed on 19th day of December 2023 and reply on points of law filed on 13th day of April 2024 and adopted same as legal submission in the aid of the case of the first to fifth defendants and urged this court to dismiss the suit. Counsel for the sixth defendant, S. Sonny Esquire, identified his final written address filed on the 15th day of January 2024 and adopted same as legal submission in the aid of the case of the sixth defendant and urged this court to dismiss this suit. Counsel for the claimant, Olasebi Kankayode Sam, identified his final written address filed on the 7th day of February 2024 and adopted same as legal submission in the aid of the case of the claimant while urging this court to grant the claim of the claimant. Let me briefly state the case of the claimant in brief. The case of the claimant is that, consequent upon his application to the first defendant, he was offered a temporary appointment as a chief legal officer of the first defendant. And upon his temporary appointment by the first defendant, he was asked and directed to act and represent the first defendant in quite a number of meetings and events, Before his formal appointment as the chief legal officer, he was made a member of the committee of the first defendant, via the letter titled Committee on Basic Programs, dated the 28th day of February 2017. He attended the inaugural meeting of the Committee on Basic Programs of the Federal University of Turkey, which was held on the second day of March 2017. After being satisfied by the first defendant, the second defendant, through a letter issued and signed by the fourth defendant, offered him a temporary appointment as the chief legal officer of the university on the 22nd day of May 2017. Thereafter, the second defendant announced that the claimant is the new appointed chief legal officer of the institution in one of the institution's management meetings, which comprised of principal officers, professors, and head of departments of the institution, including the sixth defendant. After the claimant endorsed the counterpart of the original letter of appointment and returned same personally to the appropriate authority, the then acting chief registrar of the institution, Kenneth E.T. Soranden, to assure them of his commitment, the claimant was issued with a medical, birthday, and other accompanying forms of the institution by one Mrs. Rita Agonadi of the establishment office under the registry as she then was. Based on the forms, he was supposed to undergo medical examination before his assumption of office. All the above is to accomplish within 3 months. Forms which were filled immediately after the counterpart letter of appointment were submitted to the fourth defendant. The claimant was duly informed that the officer in charge of medical services was not around to attend to him, a situation that made it impossible for the claimant to complete, submit, and conclude his documentation that same day. In less than 24 hours after the claimant was announced as the chief legal officer of the first defendant, the sixth defendant with his group began to protest heavily against the appointment of the claimant at the instigation of the fifth defendant, who was the then acting deputy vice chancellor. The sixth defendant and his team protested against the appointment of the claimant solely because the claimant was a Yoruba man and not a native of Bayelsa State, and which placards in their hands. The claimant further stated that due to the life-threatening nature of the protest, some concerned citizens of the institution wrote to the Director of State Security Service and to the press. On the 23rd day of May 2017, the sixth defendant, at the instigation of the fifth defendant, proceeded with a heavy threat to the life of the claimant and warning the claimant not to be seen anywhere around the school premises. The claimant was unable to return back to the first defendant university premises with the already issued and filled medical forms, assumption of duty forms, staff payment information form, inclusive of his already written letter of acceptance. It was due to the threat of the protesters that the Commissioner of Police and the former Vice Chancellor advised the claimant not to step into the school premises because his life is not safe until the matter is resolved. When the protests continued to grow intense, a petition was written to the police command by the protesters. Some other well-meaning concerned group of the University of Turkey, political appointees, and well-meaning indigents wrote to other responsible quarters, such as 16th Brigade Nigerian Army and State Security Service and the press, decrying the said action. The claimant reported the issue to the chairperson of the University Governing Council, Senator Shola Saraki, who wanted to look into the said issue between the sixth defendant and the claimant by setting up a committee headed by Professor Shilba Leona, but the said non-teaching senior staff association of Nigeria Universities, Federal University of Turkey, frustrated the committee, and the committee could not hold due to threat and several false publications against Senator Shola Saraki on the subject matter. The then acting registrar to the institution made a nationwide publication through the Nation newspaper on the 9th day of June 2017, condemning the acts of the sixth defendant. The fourth defendant, having decreed the acts or conducts of the sixth defendant, elucidated the legality of the appointment offered by the former Vice Chancellor, Professor Thet Akra Jaja, and also exonerated the former Pro-Chancellor, Senator Gbemisola Saraki, as one who influenced the appointment of the claimant, and merely a confirmation that there was a protest and threat to life of the claimant, which prevent him from the immediate assumption of office, returning his letter of acceptance with other accompanying forms. Regardless of the honest publication by the fourth defendant and other well-meaning groups and other concerned groups, the defendants still remain resolute in their will, and the first and third defendants have done nothing till date to conclude the said issue. The well-meaning indigents of Bayelsa State, and even the former special advisor to the governor of Bayelsa State, Senator Seriake Dixon, on non-indigent affairs, decreed same. Several arrangements for the resolution of the protest made, but all failed, as the sixth defendant, on the instigation of the fifth defendant, were unwilling to back out from same. Even the former vice-chancellor's personal efforts to resolve same also failed, regardless of his promises that it was a minor matter, and that he must resolve same in less than 2 weeks. After having waited and without any result on the issue, the claimant now decided to approach the National Assembly through his petition, written on the 3rd day of December 2019. And during the tenure of the former Vice-Chancellor, after much awaiting and several attempts and efforts at resolving the issue, he wrote a petition to the third defendant chairman. The claimant was surprised to hear from some of the staff of the institution that the incumbent Vice-Chancellor, Professor Teddy Charles Adayas, opened the service of the National Assembly petition on him on the 16th day of February 2020. He began to call them, threatening them to refute all their publications and petitions against the protesters, and attendant delay in resolving the claimant's case. That was when the claimant began to suspect that he was the architect of his problems. The National Assembly now acted on the petition already before them, invited parties concerned to appear before it on the 24th day of March 2021. On the 4th day of May 2021, the claimant was called upon to repeat his petition before the committee established in relation to same headed by Honorable Jerry Lagos, Chairman, Committee on Public Petitions, House of Representatives, in the presence of the second defendant, the registrar, and the bursar of the Federal University of Tokyo, and which the claimant did by repeating the content of his petition and praying the House to resolve the matter and pay him his already accumulated salaries with other benefits, bonuses, emoluments, and entitlements. Because he was not the one who willingly refused to accept the said appointment, but the protesters who are also threatening to kill him if seen anywhere around the school. While in the committee chairman's office, the incumbent vice-chancellor told the head of the panel that they will go back accordingly and have the governing council resolve said, but craftily said that the said position will be advertised and the claimant shall be given the prime consideration for the said position, as the position was still vacant. The chairman of the committee and other members presented countered and blatantly told him that he should do his earnest to resolve the issue, as any issue encouraging ethnic divide are not proper to be presented before the floor of the House. But perchance he doesn't want to act right, that they will be left with no option than to present same to the floor of the General House and see how a party who is championing the disunity of the country may appear before the open house of the National Assembly as of right. This idea, the committee condemned and told the incumbent vice chairman that there was no need for advertisement since the university, the incumbent vice chancellor, sorry, not vice chair, vice chancellor, that there is no need for advertisement since the university had already issued a letter of appointment upon the former vice chancellor's exercise of his powers, and the said seat and that of the Director of Legal Services, which the complainant applied for till date, remains vacant. Let me briefly state the case of the first to fifth defendants in brief. The first to fifth defendant stated that the first defendant as named herein is not a corporate soul established by any non-act of the National Assembly as a tertiary institution in Nigeria. Therefore, the second to fifth named defendants are not known as administrative head, council created within the first defendant, registrar or occupant of the office of the second named defendant. The fifth defendant, nor any other defendant, instigated the sixth defendant or any other person or group of persons to carry out any act to foil any appointment or assumption of office of the claimant or any other person offered appointment by the university. The protest was by the Senior Staff Association of Nigerian Universities, SASAN, Federal University of Turkey chapter, against the appointment of the claimant for not following due process, as the Office of Director of Legal was never advertised by the university. The protest only lasted for a few hours on the said day and was called off after the then Vice Chancellor addressed the Senior Staff Association of Nigeria, Federal University of Turkey chapter, and confirmed his entitlement as Vice Chancellor to offer temporary appointment, which is what was offered to the claimant. The first to fifth defendant stated that the claimant was offered temporary appointment by the Federal University of Turkey as Chief Legal Officer on 2nd May 2017, by the then Vice Chancellor of the university. The claimant was never a staff of Federal University of Turkey before the said offer was made to him, and up to now he is not a member of staff of the Federal University of Turkey. The Federal University of Turkey retained the professional service of claimant to represent it as an ad hoc member of the Joint Committee on the Establishment of Basic Study Program, which was set up by the university together with the representative of Divine International School. The retainer of the service of the claimant was not as a member of staff or legal officer of the university. The claimant, however, did not accept the offer of temporary appointment made to him by the university within the required 3 months from when the offer was made to him, and as such, he was never employed by the defendant. That at no time did the University of Turkey, through any of its principal members or any other member of staff, made any announcement in any meeting that the claimant is the newly appointed chief legal officer, and no one could have rightly done that without the certainty of the claimant's acceptance of the appointment and procession of all other conditions of temporary offer of appointment. It is the policy and the requirement of Federal University of Turkey that before any person can assume duty as a member of staff of the university, such prospective staff will have accepted the offer appointment made and also to satisfy all the required conditions of employment stated on the letter of offer of appointment. The protest, therefore, did not in any way prevent the claimant from proceeding with his acceptance of offer of temporary appointment and satisfaction of all other conditions of appointment. That at no time did the Commissioner of Police, the former Vice Chancellor of the university, or any other person advise the claimant not to step into the premises of the Federal University of Turkey on any purported basis of his life being under threat. The Commissioner of Police will have swung into action by investigating, arresting, or inviting the suspect behind such criminal act. Nobody wrote any letter or petition indicating the issuance of threat to the claimant or any other person, as such allegations, if any, were rather spurious and untrue. There was no committee set up by the chairperson of the University Governing Council or any other person to look into any issue between the claimant and any of the dependents at any point in time. And there was no dispute concerning the offer of temporary appointment made to the claimant. Therefore, the university is not aware of any threats or false publication made against Senator Gbemi Shola Saraki that frustrated any such purported committee. There is nowhere in the publication made by the registrar of the university that confirmed that the claimant's life was threatened, hence prevented him from returning his letter of acceptance with other accompanying documents. Upon his assumption of office, the Vice Chancellor of the university, his attention was called to a sermon or hearing notice at the National Assembly, which he had then attended and made presentation on behalf of the university. The claimant before the National Assembly Committee hearing, upon invitation to present his case, presented a case of tribal discrimination, an issue which has nothing to do with the temporary appointment offered to him by the University of Turkey. The claimant did not state before the National Assembly Committee that he did not accept the temporary appointment offered to him and did not complete the process required for him to be validly employed so as to be entitled to salary, emoluments, and benefits, bonuses, and other benefits accruing to members of staff of the university, which is the issue or the subject matter of the suit. That the fifth defendant did not and could not make the governing council made up of people from diverse backgrounds to see the claimant as an enemy to the university. But the fifth defendant also did not lie to anybody on what transpired at the National Assembly Committee. Let me briefly state the case of the sixth defendant in brief. The sixth defendant stated that as the chairman of a senior staff association of the first defendant, himself and members of the union became worried that the former acting registrar of the first defendant, Kenneth East, surrendered without advertising the position of chief legal officer of the first defendant, which some of the staff of the university, who are equally legal practitioners, are qualified to apply, carried out the peaceful protest on the 23rd day of May 2017 within the university to protect the interests of the members who are equally qualified to apply for the position of chief legal officer. That the protest, which was peaceful and non-violent, did not last up to 2 hours in the university before it was stopped. That the first to fifth defendants did not instigate the sixth defendant to carry out the peaceful protest, as the protest was targeted at the action of the first to fifth defendants, which the sixth defendant and his members believed was not in their best interest. that the peaceful protest was not for any ethnic or religious group, but solely to protect the interests of senior staff of the university who are equally qualified for the position, but it was not advertised for employment by the university, and thereby denying members to apply. And immediately the former vice chancellor came and addressed members of the sixth defendant, stating that the rules and regulations governing conditions of service of senior staff of the university empowered him to make temporary appointments, subject to the approval by the governing council. And when this explanation was made to the sixth defendant and his members, the peaceful protest was immediately stopped and normalcy returned to the university. That the peaceful protest did not even last up to 2 hours, and the claimant was not even in the university at the time, as the protest was not targeted or directed at him, but to the first to fourth defendant, as the fifth defendant was never a party to the incident at that time. That the sixth defendant and his members never threatened the life of the claimant. Later, the sixth defendant and some of his members were invited by the police upon petition written by an unknown group of persons. And the sixth defendant honored the petition, wherein the matter did not go any further because there is no any iota of proof in the allegation at the police station. The sixth defendant and members of Senior Staff Association of the University never threatened the life of the claimant, as they never had direct or indirect contact with the claimant. So counsel for the first to fifth defendants formally nominated 2 issues for the determination of this suit, to wit, whether the respective grounds of objection raised by the first to fifth defendants are sustainable on 1, whether the document tendered and provisionally admitted as exhibits CW2 to CW12 are inadmissible in law and therefore liable to be rejected. And then whether paragraph 6, 17, 20 to 38 of the claimant's statement of material facts and paragraph 10 and 12 of the reply to first to fifth defendant's statement of defense are entitled to be struck out for offending the rules of pleadings. And secondly, whether the claimant has failed to establish his case in the complaint and is therefore liable to be dismissed. Counsel for the sixth defendant nominated 2 issues for the determination of this suit, to wit, whether this suit was filed timely by the claimant and therefore was not caught up by the statute of limitation to deny this honorable court, determine the merit of the case, and also if Mr. Kalizibe Joseph was a necessary party in this suit. And secondly, whether from the total evidence before this court, the peaceful, non-violence, and non-life-threatening protest by the sixth defendant and others was proved as reason why the claimant could not have perfected his relevant documentation of his employment as chief legal officer of the first defendant. Therefore, is entitled to his claim jointly and severally against the sixth defendant. Counsel for the claimant, on the other hand, nominated 2 issues for the determination of the suit, to wit, whether DW1, DW2, and DW3 are witnesses of truth that the court can rely on their testimony in arriving at a just conclusion. And secondly, whether the claimant approve his case on the preponderance of evidence or balance of probability to be entitled to the relief sought in their statement of claims. I have carefully gone through the issues nominated by counsel for the respective parties. Issue 2 nominated by counsel for the first to fifth defendants and issue 2 nominated by counsel for the claimant are the same. The issue raised by parties are very crucial to the determination of this suit. I hereby adopt the issue nominated by parties. I will resolve issue 1 nominated by counsel for the first to fifth defendants and issue 1 also nominated by the sixth defendants separately, while I will consolidate issue 1 and 2 nominated by counsel for the claimant. Issue 2 nominated by counsel for the first to sixth defendants and issue 2 nominated by counsel for the sixth defendant, and I will resolve them together. So I will skip your final written address, your arguments, canvas, the arguments, canvas, and the final written address. So I will go to the court decision. Can you hear me? Can you hear me? Okay. Having thoroughly digested the pleadings, evidence, and the legal submission of parties in this suit, I have stated that all issues raised by parties will be considered, and I will now proceed with them one after the other. On the first arm of issue 1, raised by counsel for the first to fifth defendant, where counsel argued that the claimant's statement of claim and reply to the first to fifth defendant's statement of defense contains several averments that do not meet the necessary legal requirements. Specific paragraphs are 6, 17, 20, 21, 23, 24, 26, 27, 32, 35, and 38 of the statement, and paragraphs 10 and 12 of the reply violate the pleading rules and should be struck out. The inner defects include scandalous allegations, accusations against non-parties, and unparticularized claim of crime. According to Order 30, Rule 3 sub 1 of the National Industrial Court of Nigeria Civil Procedure Rules 2017, pleadings must consist solely of material facts, excluding scandalous averments, which should also be struck out. I have scrupulously read through the set paragraphs of the statement of facts, and also paragraph 10 and 12 of reply. And I also read Order 30, Rule 3 sub 1 of the rules of this court. Order 30 provides, and I quote, every pleading shall contain a statement in summary form of the material facts on which the party pleading relies for the party's claim or defense, as the case may be, but not the evidence by which they are to be proved, and shall, when necessary, be divided into paragraphs and numbered consecutively. It is imperative to note that in civil proceedings, the function of pleadings are as follows. They are to serve to inform the opposing party and the court of all the essential and material facts relevant to the case. They are to enable the opposing party to understand the specific issues they will face at the trial so as to adequately prepare for defense. They are also to define the pertinent issues, thereby narrowing the scope of controversy between the parties. See the cases of Crush Rock Industry Limited against Ububa, Shodipo against Lamin Kamen, KR Textile Allied Products Limited against Henry Stepping Shipping Company, Overseas Construction Company Limited against Creek Enterprises Construction Company, and Ajikawa and Saldo Nigeria Limited. All citations provided. Thus, the fact that the claimant averred that the fifth defendant instigated the sixth defendant to protest the appointment of the claimant does not make the pleading scandalous. The averments in the paragraphs complained of are remote to the claim of the claimant. While the claimant can allege, it is the duty of the defendants who disagree with the averments made by the claimant to controvert the assertion of the claimant, and the court must determine whether the claimant has proved his case or whether there is a lawful justification for the act of the defendant. Thus, paragraph 6, 7, 20 up to 38 of the statement of facts and paragraph 10 and 12 of the reply are not scandalous, and I hereby refuse to accede to the request of the first to fifth defendants to strike out the said paragraphs, and I so hold. On the second arm of the issue, one raised by counsel for the first to fifth defendants, counsel submitted that the documents provisionally marked as Exhibit CW001 to CW012B, C, and D are inadmissible and are therefore liable to be rejected and expunged from the record of this court. Argued that online copies must have certificate of compliance prepared and issued by the officer in charge of the computing devices or the person operating said. Counsel cited Section 84 sub 4A of the Evidence Act 2011 and submitted that the said documents failed to meet the admissibility requirement of the Evidence Act 2011 and National Library Act. The communal provisions of Section 2 sub 2A, 4 sub 1, and 7 sub C of the National Library Act 2004. Newspaper publications are public documents within the contemplation of Section 102B of the Evidence Act 2011. Submitted that in addition to any other requirement, such as Section 84 of the Evidence Act 2011 for electronically generated documents, such newspaper publications must also satisfy certification requirement of Section 104 105 of the Evidence Act 2011. Counsel even cited the case of Agbaya against INEC. Counsel for the first to fifth defendant, by his argument, challenges the admissibility of Exhibit 0W2 to 0W12D on the ground that this exhibit did not meet the requirement of Section 84, 104, and 105 of the Evidence Act, and also Section 2 sub 2A and 4 sub 1 and 7 sub C of the National Library Act 2004. I critically look at these exhibits. Exhibit CW002, CW003, 8, and 9 without the aid of any microscopic device. It delineates that these exhibits are public documents and they are certified in compliance with the provision of Section 104 of the Evidence Act. Thus, the contestation of counsel for the first to fifth defendants on the admissibility of these exhibits is distracting and weak, like a balloon filled up with air. Exhibit CW004 to CW007 are online publications. Curiously, can we rightly say that Exhibit CW004, 5, 6, and 7 are newspapers within the context of the newspapers as used in Section 2 sub 2A, 4 sub 1, and 7 sub C of the National Library Act 2004? The Act does not define newspapers. The only dictionary meaning of newspaper is a printed publication, usually issued daily or weekly, consisting of folded, unstapled sheets containing news, articles, advertisement, and correspondence. Therefore, an online publication cannot be construed as a newspaper within the meaning of Section 2 sub 2A, 4 sub 1, and 7 sub C of the National Library Act 2004. Thus, Exhibit CW004, 5, 6, and 7 are not public documents which require certification in accordance with Section 104 of the Evidence Act. The first to fifth defendants also raise an eyebrow that Exhibit CW004, 5, 6, 7, and 8 do not comply with Section 84 of the Evidence Act, which requires a certificate of compliance, and argues that the certificate as required by Section 84 sub 4A of the Evidence Act 2011 must either identify the document containing the statement and describing how it was produced, or give particulars of the devices, that is the computing set, as well as the printer involved in the production of the said document, to show that the said documents were produced by computer. With due respect to the learned counsel to the first to fifth defendants, I suppose if learned counsel for the first to fifth defendants was meticulous enough to have a deep perusal of the said exhibits when these documents were tendered, I believe learned counsel for the first to fifth defendants will not raise this issue of compliance of Section 84 of the Evidence Act. Each of these exhibits mentioned has a certificate of compliance attached to them, and the claimant, who is the producer of this exhibit, gave a detailed explanation of the working condition of Hewlett-Packard laptop X360 computer that was used to download or produce exhibit CW004, 5, 6, 7, and 8, and the Hewlett-Packard DeskJet Ink Advantage 3835, all in one printer that was used to print the said exhibit. Without gainsaying, parties can raise any legal issue that will assist the court in determination of the suit, but that does not encourage raising issues that do not reflect evidence record of the court. Assuming that exhibit CW002 to CW012D did not meet the requirement of Section 84, 104, and 105 of the Evidence Act, as argued by the learned counsel to the first to fifth defendant, Section 12 sub 2B of the National Industrial Court Act has laid down the requirement of certification of photocopies of public documents pursuant to Section 104 of the Evidence Act and certificate of compliance pursuant to Section 84 of the Evidence Act. The Court of Appeal, in the case of Mr. Victor Adegboyu against United Bank for Africa, unreported, appeal number CA/IL/20/2021, the judgment which was delivered on Thursday, the 14th day of April 2022, elegantly elaborated on the importance and purport of Section 12 sub 2B of the National Industrial Court Act, where my Lord, Honorable Justice Ikechukwu Amadi JCA held that, and I quote, "The National Industrial Court is a specialized court established to handle labor and employment-related matters for two specific reasons. The first reason is to ensure that such matters are determined expeditiously and without delay, as opposed to trial in the ordinary court. This reason is very crucial, considering the fact that labor rights are primarily rights in personnel as against rights in rem, in which case time is of essence in determining such rights. Globally, the resolution of the labor dispute is guided, among others, by this principle that it is better to have a bad decision quickly than a good decision too later. C. BB National Industrial Court, jurisdiction, how narrow is narrow? Hybrid Council, Lagos 2021, paragraph 13 at page 7. This first reason also underscores the importance of labor as a factor of production, which is very critical to economic growth and development of the country. The second reason, which is equally very important, is to ensure that technicality is not allowed to operate in the court against substantial justice. To achieve this, the National Industrial Code Act 2006 statutorily and clearly provided in Section 12 sub 2 that the court may regulate its procedure and proceeding as it thinks fit and shall be bound by the Evidence Act, but may depart from it in the interest of justice. I must use this opportunity to state clearly that this court, in the case of SEC against Abilu, suit number CA/A388 2013, the judgment which was delivered on 21st December 2016, did not invalidate nor diminish any manner or form the provisions and the intendment of Section 12 sub 2 of the National Industrial Code Act 2006. So this thing is, the court is a very long one. So I will end it by I will read the last paragraph. In view of the foregoing, I hold that Section 12 sub 2 of the National Industrial Code Act 2006 ought to apply to this case and is hereby applied. The lower court ought to have departed from the provision of Section 84 of the Evidence Act 2011, which is hereby departed from. Consequently, the order of the lower court discountenancing and expunging the said exhibit V814 is hereby set aside. The said exhibit B814 is to be given its probative value. This issue is consequently resolved in favor of the appellant and against the respondent. Unquote. In view of Section 12 sub 2 of the National Industrial Code, the requirement of certification as per Section 104 of the Evidence Act in this court can be jettisoned in this court. Consequently, exhibit CW002 to CW012D are admissible, given the provision of Section 12 sub 2 of the National Industrial Code Act. Therefore, EC1 nominated by the first to fifth defendants is hereby resolved in favor of the claimant, and I so hold. On EC1 nominated by counsel for the sixth defendant, the said issue is a double-barrel issue, which borders on statute bar and whether the sixth defendant is a necessary party to the suit. On the leg of EC1, counsel for the sixth defendant argued that Section 2A of the Public Officers Protection Act read limits of time. The action, prosecution, or proceeding shall not lie or be instituted unless it is commenced within 3 months next after the act, neglect, or default complainant, or in the case of continuance of damage or injury, within 3 months next after the season thereof. The time or period of limitation is determined by looking at the writ of summons and the statement of claim alleging when the wrong was committed that gave rise to the cause, cited the case of Ansar against Etim. From paragraph 12, 13, and 17 of the statement of facts, the appointment and the purported wrong of not allowing the claimant to fulfill his appointment condition took place on the 22nd day of May 2017. From paragraph 40 of the statement of material facts therein, the claimant wrote a pre-action notice dated 10th May 2022. As at 10th May 2022, when that letter was served on the defendant, that all continuous wrong came to an end. Thus, the claimant's time to sue or bring an action start to run from that day, for which the 3 months to come, for the purpose when the claimant's time to sue begin to run. See parole establishment against NNPC. I have prudently read the submission of learned counsel for the sixth defendant, and sixth defendant's objection is hinged on the argument that the claimant's suit is statute barred, reliance being placed on Section 2A of the Public Officers Protection Act. By way of recap, may I start by saying that on the authority of Modipolio against Inkandling and the case of AG Federation against Guardian's newspaper, or citation provided, the competence of a court in the exercise of the jurisdiction is determined, A, if it is properly constituted with respect to number and qualification of its membership, B, the subject matter of the action is within its jurisdiction, C, the action is initiated by due process of law, and D, any condition to the exercise of jurisdiction has been fulfilled. For a court to be competent to assume jurisdiction on a matter, the outlying condition must be conjunctively fulfilled. Flouting one of these ingredients for the determination of the jurisdiction of the court render the suit infertile to activate the jurisdiction of the court. The plenary objection of the defendants is founded on item D of the ingredients for the determination of jurisdiction. Having carefully gone through the facts of this case, as contained in the statement of facts, the claimant was offered temporary appointment on 2nd May 2017, beared Exhibit CW011, but was not allowed to have access to the first defendant campus because of the alleged protest by the sixth defendant and his group on the ground that the claimant is a Yorubama and not a native of Bayelsa State. The claimant wrote a petition to the National Assembly. The National Assembly now acted on the petition already before it, invited parties concerned to appear before it on the 24th day of March 2021. On the 4th day of May 2021, the claimant was called upon to repeat his petition before the committee established in relation to SEN, which was headed by Honorable Jerry Alagbus, who is the chairman of the Public Petitions Committee of the House of Reps. And in the presence of the second defendant, the registrar, and the bursar of the Federal University of Turkey to resolve the matter and pay him his already accumulated salaries with other benefit, bonuses, emoluments, and entitlements, because he was not the one who willingly refused to accept the said appointment. But the protesters who were also threatening to kill him if seen anywhere around the school. While in the committee chairman office, the incumbent vice chancellor told the head of the panel that they will go back accordingly and have the governing council resolve the matter. Now, given the trends in the labor law jurisprudence, the pertinent question to now ask is whether this suit is caught up by Section 2A of the Public Officers Protection Act, which I will skip this. I have mentioned the trajectory on the issue of limitation law, application of limitation law before the National Industrial Court. I stated all. If you see the judgment, if you read the judgment, you will see it there. So on this fact, I cited the case of Recto Para Poli against Adefili, reported in 2024, 9 NWLR Part 1944-529, where the Supreme Court held, and I quote, "It has long been settled by this court that the Public Officers Protection Law, the appellant raised their challenge to the competence of this suit, does not apply in breach of contract cases. In Rahmaniya United Nigeria Limited against Minister of the Federal Capital Territory, this court pointedly restated that the principle that the Public Officers Protection Act or law is not intended by the legislature to apply to contracts. Accordingly, since the respondent instant action is ground in contract, the defense the appellant seek to raise remains legally unavailing." Unquote. Flowing from the foregoing, the provision of Section 2A of the Public Officers Protection Act do not apply to the claim of the claimant, as the claim of the claimant relates to breach of contract of service, and I so hold. Assuming the statute of limitation applies to the employment contract, I do not think the provision of Section 2A of the Public Officers Protection Act can avail the defendant, given the facts of this case. The first defendant offered the claimant a temporary appointment. It was alleged that the sixth defendant, in concert with other members of the SASAM, staged a protest against the appointment of the claimant as an employer of the first defendant. It was alleged that the hostile nature of the protest of the sixth defendant and some members of the SASAM prevented the claimant from accessing the first defendant campus to complete the documentation for his employment. The protest against the appointment of the claimant cannot be said to be in the execution of official duty that will now clothe the defendant's public officers to benefit from the provision of Section 2A of the Public Officers Protection Act. The protest was carried indeed out in bad faith. A public officer can only benefit from the provision of the limitation law if the alleged wrong or injury occurred during the honest execution of the official duty. And I cited the case of Ezeani against Nigerian Railway Corporation, Papemu, Jesse, and also the case of Hassan Aliu and others. From the totality of the fact and evidence before this court, the defendant acted in bad faith to scuttle the appointment of the claimant. The limitation law is not designed to encourage or accommodate the abuse of office or action or activities of public officers with no semblance of legal justification. I hereby refuse to close the protest of the sixth defendant, which prevented the claimant from accessing the first defendant campus, and that the defendant cannot benefit from the provision of Section 2A of the Public Officers Protection Act, and I so hold. On the second leg of issue 1, nominated by counsel of the sixth defendant, and the sixth defendant submitted that it is improper for the claimant to sue the sixth defendant as person, that is Mr. Kelezibe Joseph, instead of suing only the Senior Staff Association of Nigerian University, Turkey. The Senior Staff Association of Nigerian University Turkey is a legal body or juristic person which can be sued and sue in that. Therefore, the claimant suing the sixth defendant, Mr. Kalizibe Joseph, in person as chairman of the Senior Staff Association of Nigerian University, has not and not more does not make Mr. Kalizibe Joseph as a competent person to be sued before this honorable court. Counsel cited the case of Nurses Association against AG Federation. Without doubt, the sixth defendant is a natural person with full legal capacity to sue and be sued. Aside from that, the claimant is his pleading and evidence before this court disclose a course of action against the sixth defendant. There is nothing before this court indicating that the Senior Staff Association of Nigerian University is a juristic person. The sixth defendant asserted the juristic personality of the Senior Staff Association of Nigerian University, but folded its arm without making a necessary application during the trial to have his name struck out or substituted for the Senior Staff Association of Nigerian University, which the sixth defendant claimed to be a juristic person, but without tendering its certificate of registration. This is very absurd. The only way to prove the identity or juristic personality of a company or a registered association is by tendering the original or certified true copy of the certificate of incorporation. See the case of Ekwezogo against registered trustee of SACF, citation provided. Thus, SU1 nominated by counsel for the sixth defendant is hereby resolved in favor of the claimant, and I so. Lest I forget, the first to sixth defendant in their pleading stated that the first defendant as named herein is not a corporation name established by any non-act of the National Assembly as a tertiary institution in Nigeria. Therefore, the second to fifth named defendants are not known and administrative head counsel created within the first defendant registrar or occupant of the office of the second named defendant. The name of the first defendant as endorsed on the originating summons or the complaint and other process of this court is Federal University of Turkey, Bayelsa State, Nigeria. The provision of Section 1 Sub 1 of the Federal University of Turkey Establishment Act 2015 establishes the Federal University of Turkey. The Federal University of Turkey is a creation of law which can sue and be sued. Bayelsa State, Nigeria is an unnecessary description or superfluity which does not affect the juristic personality of the Federal University of Turkey. In the case of MB Limited against Bazoum, citation provided, the Court of Appeal held that it is a settled law that a company being a legal person may sue or be sued, but the action must be in the name by which the company is registered, although the submission on behalf of the appellant merely that the name in which the appellant was sued does not end with the word limited, as required by every company incorporated under the Company Decree 1968. It has not in fact been contended that the name was in fact not the name of the defendant. It seems to me, therefore, that the appellant's main objection is centered around the addition of the word headquarters Benin City after the company's name, New Nigeria Bank Limited. The addition of those words after the company's name is, in my view, an unnecessary description or misnomer, which cannot defeat or vitiate the action. Unquote. To further spice this position of the law, the Supreme Court in the case of Abga against Uba, I quoted what the Supreme Court said. I will skip it. When you get the judgment, you read it. Therefore, the identity of the first defendant is not in doubt. The addition of the word Bayelsa State, Nigeria to the corporate name of the first defendant cannot vitiate the proceeding of this court, and I so hold. On issue 1 and 2 nominated by counsel for the claim, issue 2 nominated by counsel for the first to six defendants, and issue 2 nominated by counsel for the sixth defendant. From the gamut of evidence before this court, the claimant was offered a temporary appointment as chief legal officer of the first defendant through Exhibit CW011. The claimant stated that after the claimant endorsed the counterpart of the original letter of appointment and returned same personally to the appropriate authority, the then acting registrar of the institution, Kenneth E.T. Sorande, to assure them of his commitment, the claimant was issued with the medical bursary and other accompanying forms of the institution by one Rita Agonat of the establishment office under the registry. The first to fifth defendants pleaded and laid evidence to state that the claimant, however, did not accept the offer of temporary appointment made to him by the Federal University of Turkey within the required 3 months from when the offer was made to him, and as such, he was never employed by the defendant. It is clear from the foregoing fact before this court that the claimant had not submitted his acceptance letter or other documentation to complete the employment process as required by Exhibit CW011. This means that the inability of the claimant to fulfill the condition for the acceptance of the offer of temporary appointment makes the contract between the claimant and the first defendant incurred. The law is that where there is a failure of any of the requirements of a valid contract, such as intention to create legal relation, and where the contract is not a unilateral or gratuitous one, then there is a failure of contract as it is incompetent. It is not capable of any enforcement as it is not legally binding. In the case of Akinyemi against Odwa Investment Company Limited, the Supreme Court held, and I quote, a valid or binding contract to mean an agreement between two or more parties creating obligations that are enforceable or otherwise recognizable at law. It is elementary to state that there are three basic essentials to the creation of contract: agreement, contractual intention, and consideration. And the normal test for determining whether the parties have reached agreement is to ask whether there is an offer, and that offer has been by one party and accepted by the other. Unquote. Thus, it would be difficult or legally impracticable to enforce any term or benefits attached to the appointment of the claimant without formally accepting the terms of the contract of employment. However, the claimant pleaded that less than 24 hours after the claimant was named the chief legal officer of the first defendant, the sixth defendant and his group protested his appointment, even instigated by the fifth defendant. They opposed the claimant solely because he was Yorubaman and not from Bayelsa State. Concerned citizens alerted the State Security Service and the press due to the protest life-threatening nature. On May 23, 2017, the sixth defendant and the fifth defendant's urging threatened the claimant's life and warned him not to come near the school. As a result, the claimant could not return to the university with his submitted medical forms, assumption of duty forms, and acceptance letter. The claimant tendered Exhibit CW002 to CW009 to prove that it was because of the life-threatening nature of the protest by the sixth defendant and other members that prevented him from going to the first defendant to complete the employment process. The first fifth defendant pleaded and lead evidence to state that the fifth defendant nor any other defendant instigated the sixth defendant or any other person or group of persons to carry out any act to foil any appointment or assumption of office of the claimant or any other person offered appointment by the embassy. The protest was by the Senior Staff Association of Nigerian Embassies, Sasan Federal Embassy Otoke chapter, against the appointment of the claimant for not following due process as the head of Director of Legal, was never advertised by the university. The protest only lasted for a few hours on the said day and was called up after the then Vice Chancellor has confirmed that he has the right to offer temporary appointment, which is what was offered to the claimant. The sixth defendant stated that as the chairman of the Senior Staff Association of the first defendant, himself and members of the union became worried that the former acting registrar of the first defendant, without advertising the position of chief legal officer of the first defendant, which some staff of the university are equally legal practitioners, are qualified to apply, carry out the peaceful protest on the 23rd May 2017 within the university to protect the interests of members who are equally qualified to apply for the position of chief legal officer. That the protest, which was peaceful and non-violent, did not last up to 2 hours in the university before it was stopped. It is not disputed that there was a protest by the sixth defendant and some members of the Senior Staff Association, first defendant. This was admitted by the defendant. However, what is in dispute is whether the protest by the sixth defendant and some members of the SASAN was violent to prevent the claimant from entering the campus of the first defendant to complete his employment process. From evidence of the claimant under cross-examination, the claimant asserted that the protest by the sixth defendant and some members of the senior staff of the association of the first defendant and Ijo Youth Council was violent. But the claimant was not at the scene of the protest to give evidence about the nature of the protest. The claimant stated in his cross-examination that the claimant was on his way to the campus of the first defendant when the then Vice Chancellor of the first defendant, Professor Seth Akrajaja, told the claimant that the claimant should not come to the school because there was life-threatening protest due to his appointment. Evidence of the claimant on the nature of the protest by the sixth defendant and some members of the Senior Staff Association of the first defendant and Ijo Youth Council is a hearsay evidence that the court cannot rely on it. Hearsay evidence also can hand evidence of the witnesses, evidence of what he was told or what he heard from someone else. Such evidence is inadmissible to prove a fact. See the case of Doma against INEC, Federal Republic of Nigeria against Usman. The Supreme Court in the case of Federal Republic of Nigeria against Usman held that, and I quote, hearsay evidence is secondary evidence of an oral statement best described as second-hand evidence. What a witness say or he heard from another person is unreliable for many reasons. For example, he may not have understood the information or interpreters, or he may say things that were never said. Such evidence remains hearsay evidence because it cannot be subject to cross-examination in the absence of the informant or interpreters, unquote. Thus, the claimant who was not present at the scene of the protest cannot validly give an account of the nature of the protest, which prevented the claimant from accessing the campus of the first defender to complete his employment documentation, and I so hold. Again, XBCW003 is a petition written by concerned group Federal University of Turkey. And attached with XBCW003 are written statements of the witnesses at the police. There was no report of the investigation of the security agencies over the complaint contained in XBCW003. And the court cannot rely on the statement attached to the XBCW003 because the makers were not called to give evidence before this court. In the case of Benga against APC, reported in 2020, 14 NWLR Part 1744, page 248, where the Supreme Court held, and I quote, it is well settled that documents produced by parties in evidence in course of hearing are to be tested in open court before the court can evaluate them to determine their relevance in the determination of the case upon which the documents are relied on. For this reason, any document tendered without calling the maker thereof attracts no privative value in the absence of opportunity given to the other party to cross-examination for the purpose of testing its veracity. XBCW003 did not mention anything relating to the protest that occurred on the 23rd day of May 2017. Neither was there any report by the security agencies after investigating the complaint of the concerned group, University of Turkey. XBCW003 and attachment thereto have no privative value to the assertion of the claimant that the protest led by the sixth defendant was violent, which prevented the claimant from accessing the campus of the first defendant. XBCW005, 6, 7, 8, and 9 are newspaper reports of the protests that took place at the institution of the first defendant. Newspaper reports cannot generally be used to establish facts of the event. In the case of Abegunde against Ondo State House of Assembly and others, the Court of Appeal held, and I quote, somehow the lower courts did none of that but relied on newspaper reports, specifically of the Guardian and Newswatch, the 30th and 15th December, respectively, of 2011, to hold that there was indeed a division in the Ondo State chapter of the Labour Party. I have no doubt that that is a serious error on the part of the lower court. For the law is well settled that newspaper reports is a hearsay evidence and so irrelevant and inadmissible in proof of whatever is being reported there. The court held that a newspaper report is not generally admissible as evidence of facts recorded in it. Again, it's only against Tunji. Pagunmiju JC reiterated that point, holding that there is no doubt in my mind that this court cannot rely on a newspaper publication, which the first respondent relied on among other evidence. It is not easy to consider photocopies of newspaper publications as having any privative value since they have no such value. Newspaper publications are only proof that the publication was made and not the proof of the truth of the contents of the said publication. The foregoing statement of the law is also confirmed by the Supreme Court in the case of Ojukwu against Eradua. There, the petitioner appellant, Ojukwu, like the present appellant, sought to rely on a newspaper reports of alleged electoral malpractice in some part of the country to prove his election petition. That attempt failed with this report by Toby JSC in his lead judgment at page 1118, paragraph G. Toby JSC asks, what is the evidential value of newspaper reports? I do not see any, and there is none in law. Let me add that this position of the law that a newspaper report is hearsay and so irrelevant and inadmissible is proof of its content is universal. See, for instance, page 50 and 1356 of volume 1 of Sarkar's Laws of Evidence in India, Pakistan, where the landlord also has this to say, that newspaper report has no evidentiary value as it is inadmissible in evidence, unquote. XBCW 005, 6, 7, and 8 cannot be reliable sources to determine the event that took place on the 23rd day of May 2017 because the reports were not credited or made by any reporter who was at the scene of the protest. However, XBCW 005, 6, 7, and 8 can be distinguished from XBCW 009. XBCW 009 was a statement issued by the first defendant through the acting chief registrar of the first defendant. The statement published in XBCW 009 can come under the 5U of Section 42 of the Evidence Act, which provides, and I quote, a statement is admissible where the maker had peculiar means of knowing the matter and stated such statement is against his pecuniary or proprietary interest, and A, he had no intent to misrepresent the matter, or B, the statement, if true, will expose him to either criminal or civil liability, unquote. It can be deduced from XBCW 009 that there was ethnic bigotry among the employees of the first defendant, especially the host community of the first defendant, wherein the sixth defendant, in conjunction with Ijo Youth Council, led a protest against the appointment of the claimant as the chief legal officer of the first defendant. But there is nothing in XBCW 009 suggesting or delineating that the protest led by the sixth defendant was violent, which prevented the claimant from going to the campus of the first defendant for documentation of the employment of the claimant. Again, XBCW 009, which explained the nature of the employment of the claimant, was published on 9th June 2017. And there was nothing also before this court indicating that the claimant went to the campus of the first defendant for the completion of his employment document, and he was denied entry. As far as evidence before this court is concerned, the claimant has not proved by legally admissible evidence that the protest led by the sixth defendant in conjunction with the Ijo Youth Council was violent, and it is because of the violent nature of the protest that hindered the claimant from accepting the offer of a temporary appointment, which was made incurred and open until July 21st, 2017. The claimant stated that the National Assembly invited the parties concerned to appear before it on 24th day of March 2021. On the 4th day of May 2021, while in the committee chairman's office, the incumbent vice chancellor told the head of panel that they will go back accordingly and have the governing council resolve said, but craftily said that the said position will be advertised and the claimant shall be given the prime consideration for the said position, as the position was still vacant. The chairman of the committee and other members present countered and blatantly told him that he should do earnestly to resolve the issue, as any issue encouraging ethnic divide are not proper to be presented to the floor of the House. But perchance he does not want to act right, that they will be left with no option than to present same to the floor of the General House and see how a party who is championing the disunity of the country may appear before the open house of the National Assembly as of right. This idea the committee condemned and told the incumbent vice chancellor there was no need for the advertisement since the university had already issued a letter of appointment upon the former vice chancellor's exercise of his power and the said seat and that of the director of legal, which the claimant applied for still date remains vacant. That all they expect is a council amicable settlement of same, after which the parties now led preparatory to coming back to the National Assembly. However, the defendants denied the assertion of the claimant and stated that the petition of the claimant was dismissed. May I remind the parties that he who asserts must prove. Under Section 136, Sub 1 of the Evidence Act 2011, the burden of proof as to any particular facts lies on that person who wishes the court to believe in its existence. See the case of Ukpabio against NFCB and Ojo against ABT Associates Incorporated. Counsel for the claimant in his final address argued that the defendant did not tender the resolution of the National Assembly, which dismissed the petition of the claimant. Contrarily, I do not think it behoves the defendants to tender the resolution of the National Assembly, which dismissed the petition of the claimant. It is the claimant who asserted the directive of the National Assembly that is supposed to tender the resolution of the National Assembly. Failure of the claimant to put forward the directive of the National Assembly, which the claimant alleged was in favor of the claimant, cannot be placed on the defendants. A claimant must succeed on the strength of his case and not on the weakness of the defense. But where the evidence of the defense support the case of the claimant is entitled to rely on same in proof of his case. See the case of CDC Nigeria Limited and SCOA Nigeria Limited. The claimant in this instant case has not laid a shred of credible evidence in support of his case, but wanted to use the weakness of the defense of the defendants to prove his case. In summary, the claimant has failed to prove to the satisfaction of this court that the protest led by the sixth defendant in conjunction with the Ijo Youth Council hindered the claimant from accepting the offer of appointment and completing the employment documentation as required by Exhibit CW011. There is no credible evidence before this court that the protest that took place on the 23rd day of May 2017 was violent, but the claimant was prevented by the protesters from entering the campus of the first defendant. Lastly, the claimant also failed to tender the resolution of the National Assembly, which gave a directive in his favor. The case of the claimant is weak for lack of evidence. In Acme Builders Limited against KSWB, citation provided, where it was held that every claimant must prove his case. The court does not make a case for parties. If a party does not establish his case, he fails and his case is dismissed. See also the case of Alliance against Disu and the case of Ojo against Adejobi and Shell BP Petroleum Development Company against Jamal Engineering and the case of Okongu against NNPC. In view of that, issue 1 and 2 nominated by counsel for the claimant, issue 2 nominated by counsel for the first to sixth defendant, and issue 2 nominated by counsel for the sixth defendant are hereby resolved in favor of the defendants. Flowing from the foregoing, the case of the claimant is hereby dismissed for lack of merit, and I so hold.
My Lord, we are very grateful for the considered judgment of the court.
Yes.
A lot has been learned from the judgment, sir. We'll do better next time.
Thank you.
My Lord, we are also very grateful for the well-considered judgment of this court. My Lord, we want to commend you for the industry. We are very grateful for the opportunity to learn from the wealth of wisdom. We are grateful, my Lord.
So the next case is Alpios Tello. Mention the case.
Case number 2, MSCN/YENS/24, 2022 between Alkali for Student and Federal University of Georgia.
Right. Take yeah. Can this thing? I'm not here. I'm not.
They can hear you.
Yes, can you hear me? Can you hear me? They cannot.
We can hear.
Okay. Can you hear me now? Can you hear me?
My lord, I can hear you.
Okay. Yes. Representation.
Okay, my lord, I am Dr. PJ Fawe. I appear for the defendant.
Who is representing the claimant in this matter?
It's Akot.
Alpheus Taylor.
John.
I can see Hakot.
Akot
Hakot, I
John
can hear
appears
you.
for the claimant.
Yes, I can see Hakot, but I
But
can't
I
hear him.
suspect it's
Hakot, unmute your mic. Yes, Hakot. I cannot hear you. Let me just record without hearing.
my lord, I think he's struggling to, as the court pleases.
Hakot Ekpe John, the claimant. Dr. PJ Fawe.
Yeah, I'm no more in the matter now.
Hakot, you are no more in the matter.
Me, I was in court and
Hakot Ekpe John for the claimant.
if that was not
Dr.
happened,
PJ.
they did not unmute me now, so I.
My lord, I don't know if my lord can hear me now.
Yes. Hakot, I can hear you.
As the court pleases, my lord.
Yes.
Akot Ekpe John.
Yes.
With me is my learned friend, V.U. Kiani.
V.U. Kiani.
Yes, my lord. My lord, the claimant is also present.
Kiani is K-I.
Hear me. You know, there are two parties.
Kiani is K-I.
A-N-I. K-I-A-N-I.
A-N-I. Okay.
Our humble
So-
appearance for the claimant.
Yes. So this is a judgment of the court. The claimant filed a complaint pursuant to Order 3, Rule 2 of the rules of this court on the 28th day of July 2022, whereas the claimant claims against the defendants the following reliefs: a declaration to the effect that the claimant is still a staff of the first defendant, a declaration to the effect that the stoppage of the claimant's salaries, allowances, and deprivation of the claimant of his due promotions and other benefits from November 2021 till date is illegal, null, void, and of no effect whatsoever. A declaration compelling the defendant to restore the claimant to his appropriate position of promotion and to pay the claimant all his salaries, allowances, and benefits due to him from November 2021 till the defendant complies fully with the judgment of this honorable court, the sum of 20 million naira as general damages in favor of the claimant, and the sum of 1 million naira only being the cost of this suit. The claimant predicated his claim on the statement of facts and witness statement on oath filed on 28 July 2020 and rely on the further witness deposition of oath filed on the 10th day of February 2023. The defendant, having been served with the complaint, filed a statement of defense and witness deposition of oath on the 6th day of December 2022. At the plenary hearing on the 6th day of March 2023, the claimant, who testified for himself, herein referred to as CW1, identified his deposition made on oath made on the 28th day of July 2022 and further deposition on oath made on the 10th day of February 2023, adopted same as his evidence in support of his case. CW1 thereafter tendered exhibit CW001 to CW013. On the 30th day of November 2023, the defendant opened its defense. Mrs. Beogbara Roslyn, herein referred to as DW1, testified for the defendant. DW1 identified her statement on oath filed on the 6th day of December 2022 and adopted same as her evidence in support of the defense of the defendant. Again, Mrs. Tarire Dabipi, herein referred to as DW2, testified for the defendant. DW2 identified a statement on oath filed on the 6th day. DW2 identified her statement on oath filed on the 6th day of December 2022 and adopted same as her evidence in support of the defense of the defendant. DW2 thereafter tendered exhibit DW001 to DW006. Furthermore, Mrs. Nwanko Nene Justina, herein referred to as DW3, testified for the defendant. DW3 identified her statement on oath filed on the 6th day of December 2022 and adopted same as her evidence in support of the defense of the defendant. DW3 subsequently tendered exhibit DW007 to DW012 respectively. After the close of hearing of this suit, on the 21st day of October 2024, the matter came up for adoption of final written address filed by counsel. Senate counsel for defendant, Dr. P.J. Fowler, identified his final written address filed on the 12th day of January 2024 and reply on points of law filed on the 12th day of April 2024 and adopted same as his legal submission in the aid of the case of the defendant, urged this court to dismiss the suit. Counsel for the claimant, H.E. Ekpe, Esquire of counsel, identified his final written address filed on the 20th day of February 2024 and adopted the same as his legal submission in the aid of the case of the claimant, while urging this court to grant the claim of the claimant. Let me briefly state the fact that constituted the case of the claimant. The claimant stated that he is a staff of the defendant attached to the security department. In 2012, he was offered a temporary appointment as senior patrolman via a letter from the defendant dated the 19th day of April 2012, and he accepted the position out of sense of duty and patriotism to his fatherland. Since he gained or secured the said employment from the defendant, he has been discharging his duties to the best of his ability, which prompted the defendant to regularize the claimant temporary appointment via a letter from the defendant. Thereafter, the defendant confirmed his earlier temporary appointment. Further stated that after the said regularization and confirmation of his appointment, with the defendant. He has been carrying out his duties diligently, which also prompted the defendant to promote him from the rank of senior patrolman to assistant patrol supervisor via a letter dated the 14th day of May 2019. Thereafter, he was still carrying out his job assigned faithfully, and the same earned him a further promotion from assistant patrol supervisor to patrol supervisor via a letter dated the 18th day of September 2019. As a security staff of the defendant, he has been diligent in carrying out his job assignment, which earned or made two former vice chancellors of the defendant requested him as their personal security detail. To his chagrin, some security staffers of the defendant in his department started envying him because of the fact that all alongside from a few months, he had been working with the said former vice chancellors as their personal security detail, and thereby putting on suits and looking neat, coupled with the fact that he is always writing a detailed and authentic security report, which has always assisted the defendant to plan ahead in terms of protection of life and property within and outside the institution. The apostated hatred and envy towards him by some staff members of the defendant's security department come to fore in 2014, when one of the security staff of the defendant by name Mr. Paul Atu told him that some people in this department are planning against you, that when Professor Aluko tenure is over, they will deal with you. So you should be very careful. At first, the claimant did not take the affirmation advice of Mr. Paul seriously. Rather, he just smiled over it because he had not committed any wrongdoing. So he just prayed to God for divine protection, wisdom, and guidance in carrying out his assignment diligently for the defendant. It became worrisome that when one Mr. Burutu Orupati, who is also a staff of the defendant's security department again, confronted the claimant within the defendant compound and told him that one day Professor Aluko will leave this institution and he will see if the claimant will still be looking fine and putting on the suit, which no doubt came to the claimant as a huge shock. Further stated that sometimes in 2019, the Deputy Chief Security Officer of the defendant by name Mr. Ondo Bekumo called his attention a few months after the said Mr. Ondo came into the institution as Deputy CSO and surprisingly told the claimant a similar thing that Mr. Fall told him in 2014, where Mr. Ondo said that ever since he came into the institution as a Deputy CSO of the defendant, there are a series of complaints from security staff of the defendant that the claimant is dressing fine and always looking good because he has been working with vice chancellors of the defendant. And they are also complaining that the claimant is not even associating with them, that when Professor Jaja leaves office as vice chancellor, they will see if the claimant will still be looking good in the institution. Thereafter, Mr. Ondo told him to be careful with everyone in the security department, which was the same advice Mr. Paul had given to him. All the affirmation statements and advice made him very careful in carrying out his assignment in the institution, due to the fact that he began to feel that some persons are trying to implicate him and all thereafter his life. Professor Jaja thereafter served out his tenure, and Professor Teddy Charles Edes then came in as a new vice chancellor of the defendant. After Professor Jaja's tenure, he was still working in the vice chancellor's office, but 3 months later, the present chief security officer of the defendant, Biobara Makalaba Roslin, called him one fateful day and told him something similar to what Mr. Fowler, Mr. Ondo told him. Roslin then told the claimant that instead of the claimant being called over every day to answer questions, she wanted to post him out of the vice chancellor's office so as to hide and protect him from people seeing and talking about him on a daily basis, as the claimant is too young to be witnessing such envy and hatred from his fellow co-workers in their security department of the defendant, all because he has been working with former vice chancellors of the defendant for a while, and his co-workers felt that he has been making money and enjoying extra benefits therefore, which made the claimant to be scared of his life. The said chief security officer of the defendant then posted him out to Mommy Goodluck Jonathan's hotel security beat and placed him on night duty shift. And the claimant's fare came to a halt as he was going to work regularly and carrying out his duties diligently without any complaint whatsoever, because the claimant knows very well that his life was safe there. Claimant further stated, immediately after he was posted to the said Mommy Jonathan Hotel, he was called upon again and reposted back to the admin office, a place that the chief security officer of the defendant, who is the head of security of the institution, posted him out from, and stated reasons made by her. He has now been reposted back to the same place. The claimant thereafter went and complained to the chief security officer of the strange posting and said this action made him very scared of a likely setup or an affront to his life due to the sensitive nature of his job. On inquiry and investigation, the said masterminds of the apostated reposting of the claimant from Mommy Jonathan Hostel to admin office were one Mr. Brut Rupade and one Mr. Mwanko Nene Justine of the defendant's security department. Mr. Bruto, who has been planning to indict the claimant at all costs for a reason best known to him, was ordered again by the chief security officer to report the claimant back to Mommy Goodluck Jonathan's hostel, which they did while telling them not to post the claimant out of the set, lest till she direct otherwise. Claimant stated that he was called upon after a few days by the said Nene, that he had been posted out from Mommy Jonathan to admin office. The aforesaid action, conduct or action of the said Nwanko Nene Justina, the previous advice from Paul and Ondo, and that of the chief security officer of the defendant made the claimant to flee from the institution due to the perceived threat to his life and to enable the claimant to observe the state of affairs properly for a period of 1 week, 3 days. When the claimant came back to work after assured of his safety in all ramification. Not quite long after he returned back to his duty post, he started receiving calls and several text messages from one Tariq David, who is a staff of the defendant, that the claimant is invited to a panel constituted by the defendant without any query issued to him. He then assured the said Tariq that she should not worry as he will attend the said panel, and said the obvious before the panel as his precious life was in danger at the time, coupled with the fear of possible setup in the defendant. That was why he left for his own safety. So I will briefly state the case of the defendant. In the statement of the defense of the defendant stated that the claimant was a staff of the defendant, or ceased being a staff of the defendant with effect from the 14th day of October 2020. The claimant was not always been diligent in his duties, so that he has severally been verbally cautioned by his superiors. The claimant's lack of diligence, even in his former employment with the Department of State Security Service, caused him to be subjected to orderly room trial for neglect of duty and carelessly permitting a suspect to escape from custody. As a matter of fact, the claimant's employment with the DSS was terminated. The defendant further stated that there were no such transaction or discussion between the names of persons mentioned in the statement of facts and the claimant. If there are such transaction or discussion or allegation, the claimant being security personnel will have reported the said complaint to the relevant authorities in and out of the defendant for necessary action. The claimant worked with the previous vice chancellor as a personal security detail, but was subsequently deployed back to the security department when his service was no longer needed by the current vice chancellor. The claimant was posted or redeployed to Mama Jonathan's hotel on night duty shift, sometimes in March 2020. And was absent from his duty post on the 24th, 25th, 26th days of June 2020. The general supervisor of the claimant, sequel to the said conduct, issued the claimant a written query letter. The claimant was thereafter posted to administrative block gate on morning shift, but the claimant appeared not to be pleased with his deployment to morning shift. The claimant, in a short message service, SMS, exchanged with his supervisor on the 16th day of July 2020, indicated that anytime he is deployed on night duty shift, that is when he will be at his duty post. Stated further that despite the query issued against the claimant again was still deployed on morning duty shift to the administrative gate, in keeping with his text message to his supervisor, was absent from duty without permission from appropriate authority on 6, 7, 8, 9, 12, 13, 14, 15, and 16 July 2020. The general supervisor of the claimant noted this and issued another letter of query dated July 16, 2020 on the claimant. The claimant, whose attention was drawn to the query by his supervisor, refused to show up at work to receive the query letter, and also did not take any step to respond to the said query. The claimant maintained the same attitude to work and was still not was still not found at his duty post on the 19th, 2021 to 30th days of July, and also on the 2nd day of August, all of 2021, without due permission from the relevant authority. The supervisor of the claimant issued another query against the claimant, and same was brought to his attention. But as usual, he refused to receive same and also did not respond to the said query. After the issuance of the 3 queries, a memorandum entitled Abscondment, Mr. Pius T. was raised by the Chief Security Officer of the Federal University of Tokyo to the Vice Chancellor, calling attention to the conduct and attitude of the claimant to his assigned duties and posts. Sequel to the said memo, the Vice Chancellor directed the Registrar of the defendant to further directed the establishment officer to refer the complaint made against the claimant to the Staff Disciplinary Committee for investigation and necessary action. Establishment officer, pursuant to the said directive, referred the case of the claimant to the Staff Disciplinary Committee via internal memorandum. The establishment officer called and sent text message to the claimant, inviting him to appear before the Staff Disciplinary Committee in defense of the complaints against him. All the queries that were issued to the claimant by the security department of the defendant were brought to the claimant's notice via telephone calls, asking him to pick up the said queries and respond to said. But the claimant had always refused to show up and pick up his query letter or even respond to any of them. The claimant was invited to appear before the Staff Disciplinary Committee, which he did, and also submitted a written response to the allegations against him in a typewritten but unsigned document. He stated before the Disciplinary Committee that he was absent from duty without permission for some days on the claim that he perceived his life was under threat from the action and conduct and some of the staff of the defendant. The claimant did not state anywhere that he reported the said perceived threat to his life to any authority. Its disciplinary committee, after the conclusion of the hearing and investigation of the complaint against the claimant, made its report wherein it recommended the dismissal of the claimant in line with the relevant provisions of the rules and regulation governing the conditions of service of junior staff of the defendant. The claimant was called via phone by the establishment officer for purpose of being informed of the decision of the governing council of the defendant in respect of the recommendation made by the Staff Disciplinary Committee. But all was to no avail. As a result, the claimant till date has refused to pick up his letter of dismissal. It caused the registrar and the secretary to the council to issue an internal memo addressed to the university community and conveying the decision of the governing council in relation to the claimant and 2 other persons. Further stated that the claimant, after his trial before the disciplinary committee, a governing council decision, did not make any attempt to reach out to the defendant for whatever reason, and not also for any remedial action. The claimant, as usual, even after appearing before the disciplinary committee, was still not regular or diligent with his work until the governing council resolution dismissing him from service. He was thereafter, on the 14th day of October, not entitled to any payment from the defendant. Claimant dismissal from the service was in due compliance with the rules and regulations governing conditions of service for junior staff of the defendant and public service rules, hence lawful and justifiable. Learned counsel for the claimant nominated 2 issues for the determination. To wit, 1, whether from the express admission by Mrs. Tarire Dapibi, DW1, 2, Nwankone Justina, DW3, and Biogbara Roslyn, DW1, under oath or cross-examination open that they have never been the registrar of the defendant and did not comply with exhibit DW001, the relevant junior staff conditions of service before the stoppage of the claimant's salary allowances and other benefits due to the claimant from November 2021 to date, whether this court will not nullify the said illegal action meted on the claimant by the defendant and grant the claimant all the relief sought. And secondly, whether from the pleadings and evidence before this honorable, the claimant has proved his case to be entitled to all the relief sought as claimed. The defendant nominated 2 issues for the determination. To wit, whether the respective grounds of objection raised by the defendant are sustainable on 1, whether paragraphs 13 to 34 of the claimant's statement of claim are entitled to be struck out for offending the rules of pleadings, and whether the documents tendered and provisionally admitted as exhibit CW007, CW008, and 9 are admissible in law and therefore liable to be rejected. And then secondly, whether the claimant has failed to establish his case in the complaint and same is therefore liable to be dismissed. Having carefully gone through the written addresses filed by parties, vis-a-vis the pleadings and evidence led by the parties in respect of their respective cases. The two issues nominated by the claimant and the issue 2 nominated by the defendant are similar, while issue 1 nominated by the defendant goes to the issue of admissibility of evidence or pleading placed before the court in respect of the case of the parties. In view of the issues raised by parties, it is better and tidier to adopt and consolidate the issues nominated by parties for the resolution of the suit. So I will skip the submissions you made with regard to the final written addresses. I'll go to the court decision. Can you hear me?
Yeah.
I have carefully digested the submission of counsel for their respective parties in determining issues raised by parties, particularly counsel for the defendant, objected to the admissibility of Exhibit CW 007, 8, and 9, arguing that these documents were provisionally admitted. I'm a bit surprised that counsel for defendant raised and argued the issue of admissibility of Exhibit CW 007, 8, and 9, because the court had previously resolved this issue at the preliminary trial of the suit. From the record of this court, on the 6th day of March 2023, the claimant tendered the said exhibits. The court delivered a detailed ruling on the admissibility of Exhibit CW 007 to 9. While admitting Exhibit CW 007, 8, and 9, the court admitted same rely on the provision of Section 12 of 2B of the National Industrial Code Act 2006, that these documents are exhibits and where to be attached will be determined in the course of judgment. This holding does not only find the basis in Section 12 of 2B of the National Industrial Code Act, but also in the judicial decisions. I cited the case of Victor Adegboyu against UBA, where the Court of Appeal affirmed the provision of Section 12 of 2B. I will skip that decision because I read it in the other case. So as earlier held, the weight to be attached to Exhibit CW 007, 8, and 9 will be determined by other material evidence, and I so hold. The defendant further raised contestation that paragraph 13 to 34 of the defendant's claimant statement of claim falls short of pleading for offending the rules of pleading. The defendant referred this court to Section 30 of 3.1 of the National Industrial Court rules. The defendant argued that the mentioned paragraphs are scandalous. Without the nicety in belovering the court on whether paragraphs 13, 34 of the claimant's statement of facts are scandalous, the defendant cannot benefit from this provision of Order 30, Rule 18 of 1 of the rules of this court, having not raised the issue at an earlier stage of proceedings. I suppose the contestation of the defendant against the said paragraphs of the claimant's statement of facts is belated and cannot be raised in the final written address. I cited Order 30, Rule 18 of 1. But looking at it differently, the defendant ought to have drawn the attention of the court or made an application to strike out the said offending paragraphs of the claimant's statement of facts, and it will be unfair to strike out the alleged offending paragraphs at this stage. The defendant further argued that averments and pleadings that make allegations on non-parties to the suit are liable to strike out. The claimant in paragraph 13 to 34 of the statement of claim mention names of persons whose names are neither mentioned for purpose of confirmation nor joined as parties to the suit were alleged to be perpetrators of one criminal offense or exhibited unacceptable conduct against the claimant. It is a well-established legal principle that courts cannot issue orders against individuals who are not parties to a case. This rule ensures that everyone's right to fair hearing is protected. If that is indeed the situation, it is equally important to recognize that there exists a corresponding obligation for parties involved in the litigation. They must refrain from making allegations regarding individuals who are not formally part of the case. This is crucial because those individuals not being parties to the proceedings lack the opportunity or means to respond to or defend themselves against such accusations. Making unfounded allegations about a non-parties can not only undermine the fairness of judicial process, but also potentially harm the reputation of those individuals who are unable to present their side of the story. It is essential to maintain a standard of integrity and respect for all individuals, regardless of their involvement in the legal matter at hand. I draw the inspiration from the case of Faho Hunda against RCCA, where the Supreme Court held, and I quote, Mr. Agdebola Adeni The elsewhere counsel for the first and second respondent at the trial court had the authority to present his clients, and there was no evidence before the trial court that such authority was expressly limited. In the affidavit in support of the motion, which sought to set aside the judgment of the trial, the first and second respondents seriously accused the erstwhile counsel of gross misconduct, as reflected in the paragraph of the affidavit. I have reproduced elsewhere in this judgment. The said affidavit was not served on the learned counsel, who is the only person that can deny or admit the contents of the affidavit. The appellant herein was not in any position to know the communication between the respondent and their counsel. As such, he was not in a position to contradict paragraph 1 to 15 of the affidavit in support of the motion. Since the allegations against Mr. Adegbola Adeni had not been established, there was no reason upon which the trial court will have granted the application to set aside the judgment. Unquote. The claimant raised allegations against some of his colleagues who are also employees of the defendant, and those persons were not made parties to this suit to enable them to respond to the claimant's allegation against them. So the fact that those individuals are co-workers with the claimant in the employment of the defendant does not mean that the defendant can respond to allegations against them. Those allegations of facts were not raised or occurred in execution of the official assignment of the defendant. It will be safe for this court to base its decision on the allegation that will not be disproved by the defendant, because in the circumstance of this case, the defendant is not the mouthpiece of those individuals. For this reason, paragraph 13, 14, 15, 16, 17, 18, 19, 20, 22, 23, 27, and paragraph 34 of the statement of facts are hereby struck out because it cannot form the basis of the judgment of this court, and I so hold. On the main claim of the claimant pleaded in paragraph 36 of the statement of facts and lead evidence in proving the fact that he left the panel headed by Professor Akaba and went back to his duty post and started work on that fateful day without hiccups, not for the claimant to start noticing thereafter that his salary had been stopped by the defendant from the month of November 2021 till date, without any information whatsoever from the defendant. To date, no query or reason whatsoever has been given to him as to why the defendant stopped paying him his salary, allowances, and due benefits. However, the defendant stated that the claimant was invited to appear before the Staff Disciplinary Committee, which he did, and also submitted a written response to the allegations against him in a typewritten but unsigned document. The claimant in his defense admitted before the Staff Disciplinary Committee that he was absent from duty without permission for some days, on the claim that he perceived his life was under threat from the action and conduct of some members of staff of the defendant. The claimant did not state anywhere that he reported the said perceived threat to his life to any authority. After the conclusion of the hearing and investigation of the complaint against the claimant, its Staff Disciplinary Committee made its report, wherein it recommended the dismissal of the claimant in line with the relevant provisions of the rules and regulations governing the conditions of service of junior staff of the defendant. The claimant was called via mobile phone by the establishment officer for the purpose of being informed of the decision of the Governing Council of the defendant in respect of the recommendations made by the Staff Disciplinary Committee, but all to no avail. The defendant tendered DW010 and DW011. The claimant in paragraph 3 and 4 of his reply pleaded and lead evidence to state that he was not dismissed by the defendant on the 14th day of October 2020 and or dismissed at any time whatsoever from the defendant as his staff. The 9th meeting of disciplinary committee of the defendant, which was held from Wednesday, November 30th to Friday, December 2nd, 2020, to consider the claimant promotion to another level, but agreed to step down the claimant's promotion as disciplinary case is still in view at that time, as stated clearly in number 135, page 41 of the Staff Disciplinary Committee file of the defendant. At no time whatsoever that the claimant was dismissed from service of the defendant, but it was discovered after the claimant filed this case that the said committee, after hearing the claimant on Monday, 30th day of August 2021, at the defendant postgraduate school hall, West Campus, when they invited claimant to appear before them, as evidence in the message sent to the claimant by one Tareda people, who happens to be the secretary of the said committee of the defendant. The committee only recommended that the claimant should lose 1 year of seniority, as stated at pages 1 and 3 of the defendant's Staff Disciplinary Committee file, and nothing more, coupled with the fact that same was not duly ratified by the appropriate body to date. The claimant tendered exhibit CW008 and CW009. Let me address the issue raised by the defendant at paragraph 4.16 to 4.19 of its final written address. And counsel for the defendant submitted that where a claimant alleges wrongful dismissal, what the law expects the claimant to show are the terms and conditions of his contract of employment with the defendant, that the claimant was dismissed from employment, and that dismissal was not in accordance with the terms and conditions of contract of employment. Counsel even cited the case of Omonike against Unity Bank plc. A prudent reading of the pleadings, that is a statement of facts and a reply, will delineate that the claimant did not plead that he was dismissed from the defendant's service. Nor did he state that his employment with the defendant was terminated. The claimant's case revolves around non-payment of his salary. It is the defendant who asserted that the claimant was dismissed from the service of the defendant. The claimant is responsible for proving any claim made in his pleadings, while the defendant will respond based on the proof provided by the claimant. This same principle applies to the defendant. If the defendant presents any claim in his pleading, it must also provide evidence to support those assertions. In civil cases, there will be instances in which, on the state of pleadings, the burden of proof will be on the defendant. Also, as the case progresses, such a situation will arise when it may become the duty of the defendant to call evidence in proof or rebuttal of some particular points which may arise in the case. See the case of Ogbu against Walker. It is high time that I will enjoin counsel to be mindful of their choice of words in writing their briefs. It is unwise to use the words that will be an affront to the personality of the court. I express my disagreement with the language utilized by counsel for the defendant, specifically at paragraph 4.20 of his final written address, where counsel stated, and I quote, "This court decided to embark on a voyage to discover the terms and conditions," unquote. Cases are not won on strong or bad language. Counsel must therefore watch their words when preparing their briefs and making their submission in court. I rely on the case of Alon against Dandri Nigeria Limited. In legal proceedings, cases are determined primarily by the evidence presented before the court. The court does not undertake investigation or searches for evidence solely to satisfy the interests of any party involved. Regarding to analyzing the party's evidence regarding the dismissal of the claimant, the defendant claimed that the claimant was dismissed from the defendant's service and tendered exhibit DW010 and 11. However, the claimant claimed that the claimant was not dismissed by the defendant, and that the defendant disciplinary committee recommended that the claimant lose 1 year of seniority, and the claimant tendered exhibit CW008. Comparing exhibit DW010 and DW011 to exhibit CW008, these documents are public documents. Page 3 of exhibit CW008 shows that the committee recommended that the claimant should lose 1 year of seniority. Exhibit DW010 and DW011 show that the defendant's committee recommended that the claimant should be dismissed from the service of the defendant for absenting himself from duty for 24 days without justification and his insubordination to the authority. Ordinarily, the National Industrial Court do depart from the provisions of the Evidence Act in the interest of justice, as provided for under Section 12 sub 2B of the NICA. However, the discrepancy inherent in exhibit DW10, DW11, and CW8 has presented a situation in which the court will revert to the provision of the Evidence Act so as to resolve this discrepancy. Exhibit DW010, DW011, and exhibit CW08 are public documents and must be certified in compliance with the provision of Section 104 of the Evidence Act to ascertain their originality and authenticity. A public document is properly certified only after it is dated and subscribed by the public officer who has custody of the document. In subscribing to it, the public officer must state his name and his official title and sign the name. His official title and stamp on the document must be visible for all to see. See the case of Dick against an oil company limited. Where a purported certification of public document does not meet the requirement of Section 1041 of the Evidence Act 2011 relating to certification of public document, the document is legally inadmissible See the case of Akinola against Federal Republic of Nigeria, reported in 2024 at NWLR Part 1942 at page 39. Exhibit CW008 is a photocopy of the public document that requires certification, but it is not certified as required by law. Thus, its non-certification renders it inadmissible. Exhibit DW010 and 11 are also public documents. The first and last pages of Exhibit DW10 and the first page of Exhibit DW011 were certified, but not yet properly as required by the law. Subscription on Exhibit DW010 and 11 is Kenneth E. Sorande, signature and 2 different dates, without the official title of the person certifying this document, and visible stamp of the defendant. Noting the certification on Exhibit DW10 and 11 indicates the official title of Kenneth E. Sorende, the link between Kenneth Sorende, who signed this document, and this defendant. Therefore, Exhibit DW10 and 11 are not admissible. Exhibit DW010 and 11 and Exhibit CW008 cannot benefit from the refuge of Section 12 sub 2, the National Industrial Code Act 2006. They are also failed to meet the requirement of Section 104 of the Evidence Act. Hence, all are inadmissible. An eagle-eye perusal of evidence in this case from another angle, assuming that Exhibit DW010 and 11 comply with the provision of Section 104 of the Evidence Act, the defendant asserted that the defendant's disciplinary committee recommended the dismissal of the claimant from the service of the defendant. This recommendation was reached on the 10th day of August and September 2020. But there is no evidence before this court that the recommendation of the defendant's disciplinary committee has been implemented by dismissing the claimant from the service of the defendant by issuing a letter of dismissal to that effect. The defendant in paragraph 19 and 20 of Statement of Defense stated that the defendant's staff disciplinary committee, after the conclusion of the hearing and investigation of the complaint against the claimant, made its report wherein it recommended the dismissal of the claimant in line with the relevant provision of the rules and regulations governing the conditions of service of junior staff of the defendant. The claimant was called via a mobile phone by the establishment officer for the purpose of being informed of the decision of the governing council of the defendant in respect of the recommendation made by the staff disciplinary committee, but all to no avail. This abandonment is supported by evidence of DW2. The purported dismissal letter, which DW2 claimed the claimant refused to pick up, is not before this court. The recommendation of the defendant's staff disciplinary committee cannot metamorphose into the actual dismissal of the claimant from the service of the defendant without the issuance and service of dismissal letter on the claimant. In the case of Mobile Producing Nigeria Limited against another against Udo, the Court of Appeal held that the law is that a unilateral termination of contract does not terminate the contract. It is tried that a servant is generally entitled to damages in the sum of period of notice in the instant case of appeal. There is no evidence that the respondent was served with any notice of termination and is not aware of the termination of his employment in court. There is no way the defendant can claim to have terminated the employment of the claimant without issuing and serving a letter of dismissal on the claimant to give effect to the recommendation of the defendant disciplinary committee. To further concretize the claimant's stance, the claimant remains the employee of the defendant. The defendant, via Exhibit CW009, recommended the promotion of the claimant to Assistant Security Officer County 06, effective from 1st day of January 2022, and be stepped down in view of defendant disciplinary action against the claimant. While the defendant purported to have dismissed the claimant via the Exhibit DW012, which was published on 26th day of October 2022. Exhibit DW013 is earlier in time. If the defendant dismissed the claimant as the defendant wanted the court to believe, then the question is, how did the claimant get the recommendation for promotion via Exhibit CW009? For this reason, I disbelieve that the claimant was dismissed, having not been served with any dismissal letter. Therefore, this court finds the defendant having not communicated the dismissal of the claimant from the defendant's service to the claimant remains the defendant's employee. The dismissal of the claimant that was not communicated to the claimant is null and void, and hence the claimant is entitled to his salary and so hold. The claimant has succeeded in proving his case, and it is hereby ordered as follows. A declaration to the effect that the claimant is still a staff of the first defendant. A declaration to the effect that the stoppage of the claimant's salaries, allowances, and the privation of the claimant of his due promotion and other benefits from November 2021 till date is illegal, null, and void of no effect whatsoever. The declaration compelling the defendant to restore the claimant to his appropriate position promotion and pay the claimant all his salaries, allowances, and benefits due to him from November 2021 till the defendant complies fully with the judgment of this honorable court. And I award the sum of 1 million naira only as damages in favor of the claimant. I decline to award any cost. All terms of this judgment are to be complied with within 30 days from today, not without prejudice to the right of appeal by any party. And judgment is hereby entered accordingly. Yes. That's the case, that's the judgment. Can you hear me?
Can hear you, my lord.
Okay. That's the judgment of the court.
God pleases.
My Lord, we are very grateful for the well-considered judgment. We are very grateful for the industry of the courts. Well-considered judgment, my Lord.
Thank you.
My Lord, I want to also appreciate my Lord for the industry and the well-considered judgment. My Lord, I also sincerely apologize for the expressions used in my written address. I have learned, and my Lord, I promise that such words will never be used again subsequently.
Okay.
I am awfully sorry, and I am
It's all right, PJ Powell.
grateful for calling my attention to it, my Lord.
It's all right. So I'll go to the last judgment. Call it Congo Adezu.
YN+04 2022 between Congo Adezo and Intas Nigeria Limited.
Yes, parties absent.
Parties are present. The claimant is present, sir.
Lord, the defendant is also present.
Defendant represented by who? Who is representing the defendant?
My Lord Ogun Eke.
Your designation?
Deputy Legal Manager, my Lord.
Yes, representation.
May it please, my Lord. My name is
Yes.
my name is Austin Egbapike. I will spell both names, my Lord. My Austin is Osteen. Osteen. Egbapike is Igbapike. My Lord, I hold the brief of Larry Oromo. Larry Oromo is Larryrov. Surname is Ovworomoh. My Lord, we humbly appear for the claimant.
Yes. Yes.
My Lord, I am A.P. Inedi. My Lord, I humbly announce my appearance for the defendant.
Yes, Inedi, you are holding whose brief? Because you are not the one who filed all the process, you did not address the court, so you are...
Yes, my Lord. I hold the brief of TOP Afar. Although he has been appointed the commissioner in the various state government. That was why
No, Afar is now a commissioner.
Yes, my lord. That was why I didn't announce as holding his brief, my lord. If it pleases my lord, I'm holding his brief.
Okay, this is a judgment of the court. The claimant filed a complaint pursuant to Order 3, Rule 2 of the rules of this court on the 9th day of February 2022, whereas the claimant claims against the defendant the following reliefs: the sum of 10 million naira being general damages for lawful dismissal, and order setting aside the summary dismissal of the claimant by the defendant contained in the defendant's letter dated August 23, 2021, and order for payment of all his salaries from September 2021 till date, and the sum of 10 million naira only for defamation of character and general damages. The claimant predicated his claim on the statement of fact and witness statement on oath filed on 9th February 2022, and further witness statement on oath filed on the 1st day of June 2022, and the amended reply filed on 8th day of November 2022, an additional written statement on oath filed on the 22nd day of November 2022, and a witness statement on oath filed on the 3rd day of March 2023. Defendant filed an amended statement of defense and a witness deposition of oath on 18th day of October 2022. At the plenary trial on the 14th day of June 2022, where the claimant opened his case, the claimant who testified for himself hereinafter refers as CW1 identified his deposition made on oath filed on 9th February 2022, 28th March 2022, and 1st day of June 2022, and 2nd day of November 2022, and adopted same as his evidence in support of his case. CW1 thereafter tendered exhibit CW001 to CW010A to C. On the 8th day of May 2023, the claimant called Diko George, who testified as CW2. CW2 identified his witness deposition of oath filed on the 3rd day of March 2023 and adopted same as his evidence in support of the case of the claimant. CW2 thereafter tendered exhibit CW011. On the 13th day of July 2023, the defendant opened its case. Mr. Okun Eke, herein referred to as DW1, testified for the defendants. DW identified his statement on oath filed on 11th day of March 2022 and 1st day of August 2022 and adopted same as his evidence in support of the defense of the defendant. DW1 thereafter tendered exhibit DW001 to DW004A to B. After the close of hearing of this suit, on the 21st day of October 2024, matter came up for adoption of final written addresses filed by counsel. Counsel for the defendant, AP Ned, identified his final written address filed on the 12th day of December 2023 and replied on points of law filed on the 5th day of February 2024 and adopted same as his legal submission in the aid of the case of the defendant, while urging this court to dismiss the claim of the claimant. Counsel for the claimant, Larry Orogun, identified the final written address filed on 23rd day of January 2024 and adopted same as legal submission, urging this court to grant the claim of the claimant. Let me briefly state the case of the claimant in brief. The process of the case of the claimant, as pleaded in the claimant's pleading, is that the claimant was employed by the defendant as a security supervisor too on the 1st day of November 1995 and rose to be the chief security officer in charge of security at the defendant's premises in NPA Yard, Warri, Delta State, Nigeria. The employment of the claimant of the defendant is governed by the collective agreement of senior staff conditions of service between Intel's Nigeria Limited and Senior Staff Association of Statutory Corporations and Government-Owned Companies, 2020 to 2023. The claimant stated that by letter dated 23rd day of August 2021, the defendant unlawfully and purportedly summarily dismissed the claimant for gross misconduct, with effect from the 24th day of August 2021, after 25 years of meritorious service. On 19 July 2021, one Christopher Udukon, the defendant's maintenance coordinator, informed the claimant that some zinc items in the defendant warehouse were to be lifted with company truck from One to Fab Yard, where the zinc was urgently needed for renovation within the facility. The keys to the warehouse are officially in possession of the said Christopher Udukong. Mr. Christopher Udukong, on the 20th day of July 2021, without informing the claimant, carried the properties outside the defendant's yard without authorization. That the warehouse that housed the materials is directly situated by MPA access roads inside the defendant's facility, where anyone can go in and out freely. The warehouse does not have its own access gate, and no fixed security personnel is deployed there, as it is under lock. As the claimant noticed the movement of materials out of the yard, the claimant immediately swung into action and recovered the items from 2 locations inside Warri Town, where Mr. Udukong had diverted them to. The claimant made his findings and submitted his report on the 21st day of July 2021. The claimant stated further that the claimant did not connive with Christopher Udukong to take the materials out of the defendant's yard, despite the defendant's diligent investigation and recovery of the items. The defendant surprisingly issued the claimant a query on 20/08/2021, which the claimant replied on the 21st day of August 2021. The defendant accused the claimant of conniving with Christopher Udukong to actualize the easy loading and free movement of these roofing sheets out of the port for his personal interest, which is an allegation of. Can you hear me?
Yes, my
Can you
lord.
hear me?
Yes, my lord.
Okay.
Can hear, my lord.
They took light, so I'll use the phone and continue.
Record, please.
The defendant accused the claimant of conniving with Christopher Udukong to actualize the easy loading and free movement of these roofing sheets out of the port for his personal interest, which is an allegation of stealing. The defendant did not make any such finding against the claimant. No police investigation indicted the claimant. He was also not charged or prosecuted with the said offense. Consequently, being dissatisfied with the letter of dismissal, the claimant consulted his solicitor, who issued a solicitor's letter of demand dated 25th day of August 2021, giving the defendant 7 days to comply with the demand therein. The defendant has failed, neglected to comply, hence this action. Let me briefly state the case of the defendant. The defendant pleaded that the claimant was queried, investigated by a panel, and summarily dismissed for complicity and collusion with Christopher Udukong in the unauthorized movement of the defendant's roofing sheets to unknown destination, which was viewed as gross misconduct based on Article 15.4 of the Senior Staff Conditions of Service. The said Christopher Udukong admitted in his reply to the query issued to him and before the final setup by the defendant that he connived with the claimant and his subordinate to remove the items without approval, get pass, or authorization by all the approving authorities. The claimant was aware of the date the properties were carried outside the defendant's yard without authorization and actually participated and assisted by other security men to load out the defendant's properties. The warehouse is not situated directly by MP access gate, but the warehouse is situated within Terminal B, Old Port Warri, leased to a defendant by the MPA. It has exclusive control of the warehouse, as very expensive items belonging to it are kept within the warehouse, and it is not open to the public and unauthorized persons who are not allowed to access the warehouse. The first person to report to the defendant about the movement of the materials to unknown destination was one Moses Eyeli, who was responsible for the issuance of gate pass. The said Moses Eyeli sent an email on Tuesday, July 20, 2021 at about 10:44 a.m. The claimant never conducted any diligent investigation and recovery of materials, but he only went to where he directed Christopher Odutong to keep the items for him. To retrieve and return same, the claimant cleared the items to be taken out of the defendant premises without the mandatory gate pass and other authorization for his personal use, contrary to the management issue material procedure. The claimant is responsible for confirming that all the physical materials leaving the warehouse are manifested in a way before materials are released from the Senior Staff Association of Statutory Corporation and Government-Owned Companies. The defendant further stated that the claimant and other staff involved were each given different queries depending on their roles in the incident. The content of the query is a fact as disclosed by Christopher Odutong, which fact was presented to the claimant during the final investigation, where the claimant was invited to defend himself. The said Christopher Odutong confronted the claimant with the fact of his connivance, and he admitted the facts before the panel. His investigation panel looked into the matter critically and ascertained the true facts before the disciplinary action against the claimant was taken, in line with the requirement of Article 115 and Article 15.4 Collective Agreement of Senior Staff Conditions of Service. Releasing items not in line with the materials management issuing procedures constitute gross misconduct. The claimant was dismissed in line with the conditions of service, as the claimant failed to present to the management of the defendant the approvals or document authorizing the movement of the items out of the defendant's premises. The claimant was issued query to explain in writing the allegations against him, and his response to the said query was considered unsatisfactory. He was given fair hearing to defend himself before disciplinary action was taken against him. That report of disciplinary committee comprising management of Intels Nigeria Limited and representatives of the Senior Staff Association of Statutory Corporation and government-owned companies to investigate the unauthorized movement of old and new roofing sheets to a non-destination on the 19th day of July was set up. Counsel for the claimant nominated two issues for the determination of this suit. That is, whether the claimant has not proved his case to be entitled to the relief fund, and whether the claimant was wrongfully dismissed, and whether from the state of pleadings and evidence, Exhibit CW002 does not govern the employment of the claimant. Sorry, three issues. Counsel for the defendant nominated two issues for the determination of the suit. That is, whether Exhibit CW002 collective agreement can be a ground for a cause of action. And secondly, whether the claimant has discharged the onus of proof that the dismissal of his contract of his employment devoid of statutory labor was unlawful and defamatory. I have critically looked into the pleadings and the evidence led by parties and the legal submissions of counsel in support of the case of the parties. The issues nominated by parties are the same, although differently worded. Besides, the claim of the claimant before the court as endorsed in the complaint and the statement of fact are two facets. That is, the claim that borders on dismissal of the claimant and defamation. Thus, it is important to consider whether the court has jurisdiction to ascertain claims bordering on defamation. Since parties did not raise it, the court will not gloss over it by assuming the jurisdiction on the defamation. For this reason, the issue to be considered in determining this suit are as follows. Whether the court can raise and determine jurisdictional issues suo motu without hearing from parties, and whether the National Industrial Court of Nigeria has jurisdictional bars to entertain claims bordering on defamation arising from legal matter, and whether Exhibit CW002 governs the employment of the claimant with the defendant, and whether the dismissal of the claimant is in compliance with the claimant's conditions of service with the defendant. So I will skip your legal arguments. The legal arguments you converse in your final written address, and I will go to the decision part of this document. I have carefully studied all the processes filed by both parties, including the evidence adduced and the exhibit tender. On issue one, as I earlier noted, the claims of the claimant are in two forms: a claim for lawful dismissal of the claimant by the defendant and a claim for defamation arising out of the industrial relationship of the claimant with the defendant. Without guessing, this court has jurisdiction over employment-related matter, which includes termination of employment contract. I am pressed to query if this court has jurisdiction over the claim of the claimant of defamation, even though the parties are silent about the propriety of bringing the claim bordering of defamation before the National Industrial Court instead of the High Court, which has unlimited jurisdiction, subject to the provisions of Section 251 and 254C of the Constitution of the Federal Republic of Nigeria. It is fundamental to know that parties cannot, on their accord, confer jurisdiction on the court. Jurisdiction is the threshold of judicial power and judicialism, and by extension, intrinsic to the adjudication. It is the backbone of any adjudication. Parties cannot, by connivance, acquiescence, or collusion, confer jurisdiction on the court. While a court lacks jurisdiction, parties in the litigation cannot confer jurisdiction on the court. As a matter of law, lack of jurisdiction cannot be waived by one or both parties. It is a hard matter of law, clearly beyond compromise by parties. This is because parties cannot conspire to vest jurisdiction in the court where there is none. Any proceedings conducted without jurisdiction will be an exercise in futility. For such proceedings are null and void. It is for this reason that issue of jurisdiction can be raised at any stage of proceedings, even for the first time on appeal. See the case of AG River State against AG Federation. For this reason, it is legally expedient to raise the issue of jurisdiction on whether the National Industrial Court has jurisdictional gap to entertain the claim of the claimant in this suit concerning defamation. Before expanding the jurisdiction of this court, I am not oblivious of the position of the law, which requires that where a court raises an issue suo, the court shall beckon the parties to address the court on the issue raised. The Court of Appeal in the case of OG against Amara. Stanley warns that no court of law has the jurisdiction to raise an issue and resolve a suo motu without hearing from the parties. In the Nigerian advisory system of adjudication, courts should not be reluctant or loath to raise issues suo motu. This is because litigation is not theirs, but that of the parties. If a court raises an issue suo motu, it has removed itself from its exalted position to flirt with the parties and in the course get itself soiled in the litigation. Although court has jurisdiction to raise an issue suo motu, it does not have jurisdiction to resolve the issue suo motu. The court must allow parties to react to the issue by way of address. On no account shall a court of law raise an issue suo motu and resolve its suo motu. A court is not a Father Christmas, and its jurisdiction is limited to the issues presented to it. The court cannot generally make pronouncements that affect parties before it without allowing the parties to address the court of it. Notwithstanding the profound warning of the appellate courts in a plethora of judicial authorities, which enjoin the courts to be hesitant to raise issues suo motu and resolve its suo motu, authorities plenteous which state the instances where the court can raise issues suo motu and resolve its suo motu without hearing from parties. The Supreme Court in the case of Akin Loglugbe against Nirowi reported in 2023, 11 NWLR Part 1895-339, where the Supreme Court held, and I quote, "It has become accepted that a court can raise an issue suo motu and decide same without calling for address of parties in the following instances. When the issue related to the court's own jurisdiction. Secondly, when both parties are not aware or ignore a statute which may have a bearing on the case. This is because every court is expected to take judicial notice of statutes by virtue of Section 122 sub 2A of the Evidence Act 2011. And then thirdly, when on the face of the record, serious questions of fairness of proceedings are evident." Unquote. I also refer you to Angadi against PDP and others, persons named unknowns against Saharis International Limited, Omoini against Alabi. In the case of Oga and others against Igbe and others, citation provided, the Supreme Court articulated as follows. There is this misconception that in all cases where the court at any stage find that an action is manifestly incompetent, either as regard to competence, jurisdiction, or by operation of statute, it cannot on its own initiative or suo motu put an end to it without hearing from parties. English court holding on the principle that consent of parties cannot give a court jurisdiction which it does not otherwise possess. I've held that a court is not only entitled bound to put an end to proceeding if at any stage and by any means it becomes manifest that they are incompetent, and that it can do so on its own initiative, even though the parties have consented to such void action. I also cited AFIOM against Cross River Independent Electoral Commission, Pataba JSC. Those on court, those the jurisdiction of the court is a creation of statute. That is, this issue that the court raised sumo to here is a matter of law. Though the court will utilize the provision of the Constitution which create this court vis-a-vis the facts already placed before this court to determine the jurisdiction of the court. This is a jurisdictional issue which borders on law. Therefore, it is needless to call the parties to address the court on the issue of jurisdiction of court. After all, the court is expected to have all law at its fingertips. Given the above exposition of the law, it is the finding of this court that the court can legally raise the issue of jurisdiction sumo to and decide on it without the address of the parties. After all, jurisdiction is an issue of law, and I so hold. Can you hear me? Can you hear me?
Yes, my lord, I can hear you.
Okay.
Yes, my lord.
On the second arm of the issue one, another vital judicial discovery that needs to be taken here is whether National Industrial Court has jurisdiction over defamation. The question whether this court has jurisdiction over defamation in particular and thought in general has been a vexed one. The earlier decision of this court held that this court does not have jurisdiction over defamation, even if it arises from workplace. Naturally, the Court of Appeal has been approached to make a determination in that regard. Unfortunately, the decision of the Court of Appeal have oscillated in that regard. I cited the case of Akpan against University of Calabar and Bisong against University of Calabar. I also cited Medical and Health Workers Union of Nigeria against Dr. Alfred and Medical and Health Workers Union against Ehigba. I also cited Mr. Olufasan against Capital Eco Bank against Idris Adeni Olushola against Odopus Yakubu. All. So if you get the judgment, you will see the trajectory of this issue. All these appeal court decisions are later in time than the 2018 decision of Medical and Health Workers Union against Alfred Supra. And so by this law, it is compelled to follow them. This means that this court cannot exercise jurisdiction over the claims of the claim in defamation at the instant suit. This being so, Relief 4 cannot be litigated in this court, and I so hold. On SC2, as per prelude to SC1, the claimant pleaded that he was employed by the defendant. The claimant tendered Exhibit CW001 to prove his employment relationship with the defendant. The defendant admitted that the claimant was employed by the defendant. In legal proceedings, a party's admission served as the most compelling evidence, relieving the opposing party from the burden of proof regarding the admitted fact. In civil cases, such admissions are considered evidence against the admitting party. Unless valid explanations are provided to court, once a party acknowledges a fact in their legal pleadings, they are bound by this admission and cannot later dispute it. Consequently, a court is permitted to render a judgment based on these relevant admissions. See the case of Salau against Yusuf and Oseni against Dawood and Ogonu against Chiboka. More importantly, there are three categories of employment contracts: pure master-servant relationship and servants who hold their office at the pleasure of their employer and the employment with statutory labor. In the master-servant relationship, the master has an unfettered right to terminate the employment. However, he must comply with the procedures stipulated in the contract. In a contract with statutory labor, the employment is protected by the statute. In the event of termination of employment with statutory labor, strict adherence must be had to the statute. I cited OVAV against Delta Steel Company Limited, Longi against Space Bank, Mobile Oil Producing Limited against Johnson. In this instance, the defendant by its nature is not a creation of statute, but rather a limited liability company incorporated under the Companies and Allied Matters Act. Thus, the employment of the defendant claimant of the defendant does not enjoy statutory labor. That being so, the parties are bound by the agreement. The contract of service is the bedrock upon which an aggrieved employee must found his case. He succeeds or fails upon the terms and conditions thereof. Therefore, in a written or documented contract of service, the court will not look outside the terms stipulated or agreed therein in deciding the rights and obligations of the parties. See OBB against Delta Steel Company Limited. The parties here to their respective legal submissions do not agree on the conditions of service of the claimant. Ordinarily, the terms and conditions that regulate and govern employment for services are embodied and contained in the letter offering the appointment or employment from the employer and addressed to the employee, which, if accepted freely and unconditionally by him, will constitute a valid, binding, and legally enforceable agreement or contract of employment between them. It is therefore the free and unqualified acceptance of all the terms and conditions set out in the letter of appointment of the employee that forms the basis for the existence of a legally binding and enforceable relationship between him and the employer. In any action in which any of the parties claim a breach of any of the terms or conditions agreed to by parties or set out in the letter of appointment, the letter of appointment becomes a sine qua non to the maintenance and success of the action. See Omera against Insurance Law Corporation, Kato against CBN, Area against Bendel Feet, Flour Mills, Olale Khan against Management Board, and the Raji against OA, all citations provided. XBCW001 is the letter of appointment of the claim. A cursory look at XBCW001 will reveal that XBCW001 did not subject the appointment of the claim of the defendant to any conditions of service. Neither did XBCW001 spell out the terms and conditions of service of the claim of the defendant. If that is the case, will the court just conclude that there are two terms and conditions or conditions of service regulating the employment of the claim of the defendant? To answer this question, there is a need to consider pleadings and evidence before this court. The claimant in paragraph 3 and 4 of his statement of fact pleaded a collective agreement of senior staff conditions of service between Intel's Nigeria Limited and Senior Staff Association of Statutory Corporations and Government-Owned Companies, 2020 to 2023, which same is admitted in evidence as XBCW002. The defendant also pleaded XBCW002 in paragraph 9, 12, and 13 of the amended statement of defense. If pleadings are to be of any use, parties must be held bound by them. CBAC against Electrical Company Limited against Additional, Union Bank PLC against Ajabule, Kubu against Dixon, and Oruwari against Oslo. Besides, XBCW003 is the document that emanated from the defendant, the integrity of which was never challenged by the defendant. XBCW003 reads that the defendant dismissed the employment of the claimant in line with the provision of the senior staff conditions of service. The Court of Appeal in the case of Savannah Bank Nigeria PLC against Papo held that, and I quote, I agree with the submission of the appellant counsel that it is necessary for the respondent to plead and tender in evidence his letter of appointment, and failure to do so may be fatal to his case. But where there is otherwise ample evidence to establish the terms of contract of employment, failure to render the tender letter of employment will not necessarily be fatal to the respondent case. In the instance case, the respondent pleaded his letter of appointment but failed to tender it in evidence. But there are other letters tendered in evidence to show that the respondent was appointed by the appellant bank and he was even promoted and commended by his employers. I also cited the case of Kaduna Textile Limited against the defendant having relied on XBCW002, both in its pleading and evidence, cannot turn around to resile from its document. It is therefore the finding of this court that XBCW002 is the condition of service binding the claimant and the in the case of Oladipo against Shabu, the Court of Appeal held and I quote, in an ordinary master-servant relationship, the right to bring such relationship to an end has always inured to the parties' relationship. The right is either provided by the very contract between the parties or read into such contract if permitted. If it is equally the law that once a contract of service has provided a procedure for the termination of the contract, whether or not the termination of appointment pursuant to the contract has rightfully been carried out will depend on what the contract itself provided. Having established that XBCW002 is the condition of service between the claimant and the defendant, the next hurdle now is whether the defendant complies with the provision of XBCW002 before dismissing the claimant. But before that, let me address the issue raised by the defendant in paragraph 4.21 of the final written address, where the defendant argued that the claimant additional written statement on oath filed on 22nd November 2022 and adopted on 25th January 2023 was not filed by any order of this court. The entire evidence therefore should be expunged from the record of this court. The defendant has, by way of motion or notice, dated and filed 1st August 2022, sought for leave to amend its statement. The said motion was moved on 18th day of October 2022 and granted. Defendant filed the amended statement of defense on the same 18th day of October 2022, but was served on the claimant on the 21st day of October 2022. The claimant filed a consequential amended reply of claimant to the statement of defense on 18th November 2022, along with a written statement of defense. But the statement on oath raised both old and fresh issues, and as such could not adopt same. The claimant, without the leave of court, filed additional written statement on oath on the said consequential amendment on 22nd day of November 2022, outside the 14 days period prescribed by the rules of this court to file same, cited Order 26 Rule 6 of the National Industrial Court of Nigeria. It can be garnered from the legal submission of the defendant that the claimant additional written statement on oath filed on 22nd 11/2022 and adopted on 25th January 2023 was not filed by any order of this court, and the entire evidence therefore should be expunged from the record of this court. The defendant did not raise this issue of belated filing of the defendant additional written statement on oath filed on 22nd 11/2022 when the same was adopted on 25th January 2022. Therefore, objecting to its admissibility after the adoption is belated. Some objection ought to be raised before the adoption. The decision of the Court of Appeal in the case of Ogbanigbe against Abibu, the court held, and I quote, the witness statement on oath upon adoption becomes the evidence of the witness. If there is any objection or concern with the witness statement, such objection should be raised at the time the witness seeks to adopt it. Once it is adopted without objection, it is no longer open to a party to challenge the competence of the witness statement, which has translated to the witness evidence in chief. The implication of adopting an irregular witness statement on oath is that such makes the deposition admissible, unquote. Rebutting to issue 2, the claimant pleaded and laid evidence to state that on 19th day of July 2021, one Christopher Odukong, the defendant maintenance coordinator, informed the claimant that some zinc items in the defendant's warehouse were to be lifted with company truck from Onit to Fabia, where the zinc was urgently needed for renovation within the facility. The keys to the warehouse were officially in the possession of the said Christopher Odukong. The claimant stated further that Mr. Christopher Odukong on the 20th July 2021, without informing the claimant, carried the properties outside the defendant's yard without authorization, and the claimant did not connive with the Christopher Odukong to take the materials out of the defendant's yard. Despite the claimant's diligent investigation and recovery of the items, the defendant surprisingly issued the claimant a query on 20th August 2021, which the claimant replied on 21st August 2021. The defendant accused the claimant of conniving with Christopher Odukong to actualize the easy loading and pre-movement of those roofing sheets outside the port for his personal interest, which is an allegation of stealing. The claimant stated that by a letter dated 23rd August 2020, the defendant unlawfully and purportedly summarily dismissed the claimant for gross misconduct with effect from 24th August 2021 after 25 years of meritorious service. The defendant in turn responded that the claimant was queried, investigated by panel, and summarily dismissed complicity and collusion with Christopher Odukong in the unauthorized movement of the defendant's roofing sheets to unknown destination, which was viewed as gross misconduct based on Article 15.4 of the Senior Staff Conditions of Service. The case said Christopher Odukong admitted in his reply to the query issued to him and before the final settled by the defendant that he connived with the claimant and his subordinate to remove the items without approval, get pass, or authorization by all the approving authorities. The claimant was aware of the dates properties were carried outside the defendant's yards without authorization and actually participated and assisted other security men to load out the defendant property. The defendant further stated that the claimant and other staff involved were each given different queries depending on their roles in the incident. The content of the query is a fact as disclosed by Mr. Christopher, and which fact was presented to the claimant during the final of the investigation, where the claimant was invited to defend himself. The said Christopher Odukong confronted the claimant with the facts of his connivance, and he admitted the facts before the panel. The investigation panel looked into the matter critically and ascertained the true facts before the disciplinary action against the claimant was taken in line with the requirement of Article 11.5 and Article 15.4 of the Collective Agreement of Senior Staff Conditions of Service. Article 11 of Exhibit CW002 provides, and I quote, disciplinary procedure. The company reserves the right to discipline erring staff. However, in doing this, the following procedure shall apply. 1. Oral query and warning. 2. Written query and warning. 3. Suspension from work. 4. Termination. 5. Summary dismissal. In this instance suit, it is imperative to note that the claimant was served with a query, Exhibit CW007, and the claimant responded to the said Exhibit CW007 through Exhibit CW008. However, paragraph C, Article 11 of Exhibit CW002 makes it mandatory to set up a disciplinary committee comprising of management and associate representatives in cases of gross misconduct. The claimant was dismissed for gross misconduct. Thus, subjecting the claimant to disciplinary committee becomes mandatory. The defendant pleaded and lead evidence to state that the defendant subjected the claimant to a disciplinary committee to investigate gross misconduct against the claimant. However, the claimant pleaded and lead evidence to state that the defendant did not set up any disciplinary committee to investigate gross misconduct against the claimant in compliance with the provisions of Article 15 of Exhibit CW002. However, the claimant further stated that the defendant did not set up any disciplinary committee, but the claimant was invited to Port Harcourt, where the claimant met Christopher Oduton, Gabriel Adeomi, and Jacob Orere with some staff of Prodeco Limited, and there was no any member of the Senior Staff Association of Statutory Corporation and Government-owned companies. The pertinent question that deserves an answer is, was there any disciplinary committee to investigate gross misconduct against the claimant? Let me rehash the evidence of the claimant, where the claimant stated that the defendant did not set up any disciplinary committee, but the claimant was invited to Port Harcourt, where the claimant met Christopher Oduton, Gabriel Adeomi, and Jacob Orere with some staff of Prodeco Limited, and there was no member of the Senior Staff Association of Statutory Corporation and Government-owned companies in that meeting. Another question that needs to be answered here is, what is the relationship between the defendant and Prodeco Limited? DW answered under cross-examination that Christopher Oduton worked with Prodeco Limited. Prodeco Limited is owned by the defendant, and both the defendant and Prodeco Limited operate in the same premises, and the two companies have common relationship. Thus, since there is a common interest between the defendant and Prodeco Limited in this case, the act of Prodeco Limited finds the defendants and vice versa. However, the claimant stated that he was invited to Port Harcourt, where the claimant met Christopher Oduton, Gabriel Adeomi, and Jacob Orere with some staff of Prodeco Limited. The claimant further answered under cross-examination as follows, and I quote, I did not appear before any committee by one Ekun Eke. I was issued with query on 20th of August 2020, and I was dismissed on the 23rd of August 2021 after I came back from Port Harcourt. I answered the query on the 21st day of August 2020. I did not appear before any panel. I only appeared before the Prodeco, not Intels. Unquote. It can be gleaned from the fact before this court that the procedure of the disciplinary committee in XBCW011 was not set up to investigate the claimant for the alleged gross misconduct. On page 2 of XBCW011, the disciplinary committee commenced its proceeding on 9th day of August 2020. The claimant was served with a query, XBCW007, on the 20th of August 2020, and he answered the query on the 21st day of August 2020, and he was dismissed on the 23rd. He was dismissed on the 23rd day of August 2020. If proceeding in XBCW011 was meant to investigate the claimant, there will not be any need for the query again. But the defendant issued the query without setting up an disciplinary committee after the claimant responded to the query as required by paragraph C of XBCW002, which makes it mandatory to set up a disciplinary committee in all cases of gross misconduct. It thus means that the claimant was dismissed based on his response to the query, not as a result of proceeding in XBCW011. Again, on page 3 of XBCW011, it stated that queries were served on the claimant and others, and they responded to the queries accordingly. The integrity of Exhibit CW011 is questionable for the fact that as at the time the proceeding in Exhibit CW011 was conducted, the defendant had not issued any query on the claim. The query was issued on the claimant after the claimant returned back from Port Harcourt. This, in fact, makes evidence of CW2 probable, where CW2 stated that CW2 did not sign CW011. For this reason, I refuse to believe that the proceeding in Exhibit CW011 was conducted to investigate the allegation of gross misconduct against the claimant. Flowing from the foregoing, the defendant flouted paragraph C, article 11 of Exhibit CW002, which makes it mandatory to set a disciplinary committee in all cases of gross misconduct, which attracts dismissal. It has been found that the dismissal of the claimant from the employment of the defendant contravenes Article C, paragraph C, article 11 of Exhibit CW002. The claimant pleaded and led evidence to state that the claimant will be due for retirement from the defendant in January 2020. The law is that the normal measure of damages recoverable by an employee whose contract has been wrongfully terminated is the amount he will have earned under the contract for the period until the employer will have lawfully terminated it, less any amount he could reasonably be expected to earn in another employment. See the case of Straba Construction Nigeria Limited against Adave. The claimant's employment with the defendant will have been lawfully terminated by retirement in January 2020. The claimant will be entitled to the salary the claimant will have earned if the defendant did not illegally dismiss the claimant and I so hope. Before I conclude this judgment, I charge lawyers properly study their cases and know the reliefs the court can grant in the event the claimant successfully prove his cases. The court found that the claimant was unlawfully dismissed by the defendant. The claimant is entitled to his terminal benefit pursuant to Article 14 of Exhibit CW002. But the claimant in this suit did not ask for the payment of his terminal benefit. Alas, because it's not a generous father's Christmas who doles out gift even without demand. The claimant has successfully proved his case to the satisfaction of the court, and it is hereby ordered as follows. An order setting aside the summary dismissal of the claimant by the defendant contained in the defendant's letter dated August 23rd, 2021. An order for payment of all his salaries from September 2021 to January 2022. The sum of 1 million naira as general damages. All the terms of this judgment are to be complied with within 30 days from the date of this judgment without prejudice to the right of appeal by both parties, and judgment is hereby entered accordingly.
As the court pleases, my lord, we are grateful for the industry. My client is celebrating already as I speak with you, my lord. We are grateful, sir. Thank you.
We're most grateful to my lords and considered judgment. We are grateful for the industry, my lord. I'm most grateful.
Yes.
You win your case.
The call is very else. Don't forget.
Look at it, Pastor. The answer. Pastor, my man, there. Good indeed. If I listen to judgment, yeah. The corner, they come. They come. Don't finish.